Hi, guys. Funny seeing you all here. And yes, we are going to get started on the thing we covered last night with the cops out in Tallahassee, Florida, framing a guy for DUI. And I'm not saying that lightly. They literally did frame this guy for DUI, and they completely fabricated the charges against him. And how do we know? Because we watched the body camera. And sadly, we're gonna watch all of this, and I'll spare you guys I'll spare you guys some suspense. But this has gone to trial. It went to trial today. So this isn't there's a lot of injustice here, a lot of injustice, and it's a lot of garbage. So we're gonna start off first by watching the video because I don't know if everybody's seen it, but I think you guys all need to watch it because it does reveal a lot of what happened. So also, I saw David here. David, I sent you a link, but I know you thought you said you might be going to lay down, so that's okay if you're not out there. And also, real quick, where is? Yeah. Hold on here. So, hey, McKinley, if you're out there, I sent you a link as well if you'd like to comment on this. So, this is, you guys, this is garbage. Wasn't supposed to be tomorrow at noon. No, it's going tonight. We're doing this live, chat. Are you telling me we can't trust the cops? Yeah. Yeah, so Ryan says, "The first time I've heard of this." Yeah, they've literally fabricate an OVI charge against this guy, and it's completely. I mean, it's bullshit. It is bullshit what they do to him, and it's yeah. Um. Yes, the cops got 3 weeks paid vacation and promotions. They also probably got medals for bravery for doing this. So, when are we doing the Kelly case catch up? We're going to be working on that probably on Sunday. So, and J Rock, you know, yes, they deserve prison, but in reality, they probably did get medals for bravery for this. And, you know, the fact that officer, well, we'll get to it. We'll get to it. So here we go. Here we go, guys. This is from our Tallahassee. They broke the story. I give them
Meet Calvin Riley.
So yeah, here we go. We're gonna crank this volume up a little bit. So here we go.
Calvin Riley. He's being stopped by the Tallahassee Police Department on South Monroe.
Hello, sir. I'm Officer Oliver with Tallahassee Police Department.
She'll plant evidence.
Now, I will say it is a little goofy. You stop on the left side of the road, pull over to the right, and just get over, but whatever.
Of an empty liquor bottle in Riley's car before arresting him for an alleged DUI. Riley's license is suspended, and officers decide to arrest Riley on a first offense for his suspended license.
Would you be willing to do some voluntary field sobriety exercises? Not really. Okay. Here, go ahead and step out of the vehicle for us.
They didn't tell him the consequences of refusing that voluntary test.
Well, there's no real consequence. He's getting arrested anyway. Refusing the voluntary field sobriety test, they were going to find him guilty. They were going to find evidence of a DUI against him anyway. They would say he probably smelled like alcohol. The car was swerving. That's alone is enough to sustain a conviction. But he's smart for not. You always refuse the field sobriety test, guys. You always refuse the field sobriety test. Why? Why do you refuse them? Because it's a test you can't ever complete. It's a test you'll never satisfy them. If they think you're intoxicated, you could complete the entire test, have no indications, and you could still be intoxicated. So it's a test you could completely ace and get every question right and still fail. So don't ever take it. Don't ever take it. But it doesn't matter. He's driving on a suspended license, which is a boneheaded thing to do. Don't drive on a suspended license. That doesn't help either here. Refusal is possible license suspension, but worth it at administrative hearing. That's not the test they're talking about. They said field sobriety test. The field sobriety test cannot be refused. Like, you can refuse those. Now, a chemical test is different. So, and that becomes a separate issue. And I mean, like in Ohio, if you refuse your first time OVI offense and you refuse, okay, cool. You get suspended for 1 year. If you plea out to DI, what do you pretty much get? A 1-year suspension anyway. So it doesn't actually change. Now, there are some states, though, when it comes to the actual breathalyzer machine at the police station or the blood test, if you refuse those, some states like Minnesota, it's a separate criminal offense, which I think is unconstitutional. Okay, Robert, listen. Écoutez les enfants. The field sobriety test, like doing this and walking on, like standing on one foot and walking in a straight line, those are the field sobriety tests. You can refuse those and they cannot punish you for that. They can also make you use a roadside breathalyzer. You can refuse that. The breathalyzer at the station is an entirely different subject. That one you can't refuse. That's the one you're going to get penalized for. That's the same thing for a urine test or any sort of chemical test. That's the difference. Okay, guys? That's where, like, we're way before that. We're at on the side of the road. Sir, would you like to come and talk to us? Nope. So, yeah. You're boned if you're at the station, but that's, you should talk to an attorney in your jurisdiction whether or not refusal is the right idea, because some places will penalize you. So here we go. And Robert, I know you're not saying that, but I'm just making sure we all understand we're on the same page. So that is just what I'm trying to say. A breath test can't be refused. I mean, yes, it can. I can refuse it and then my license gets suspended. So you want to take a breath test? Nope. Your license is suspended for a year. I mean, I can refuse it, but that's, yeah. Anyways, he was getting arrested anyway. So what does that mean? He's getting arrested for a suspended license. So what happens from there? Well, they're going to search his car because they're going to tow it and they're going to inventory everything. They're also probably going to claim search incident to arrest. But at the very least, they're going to claim an inventory search. So they're going to inventory the contents of the vehicle. But they also claim that on top of that, they smelled the odor of marijuana emanating from the car. The odor of marijuana. So what does that mean? Well, marijuana is still illegal in Florida, so they're going to search the car. That's probable cause. Now, do they really smell marijuana? No, they never usually do smell marijuana. They're usually lying. But here we go.
Just go ahead and face the corner of the car for us. Your license is
After
suspended,
detaining
so
Riley,
we're gonna-
they ask him if he smoked any marijuana.
Mr. Riley, I got a quick question for you.
No problem.
So I smelled marijuana in your vehicle. Did you recently smell?
No.
Once he's arrested for driving with a suspended license, they can search his car. Officer Oliver leaves the car, does a 360, and then goes back in the car, retrieving a sealed liquor bottle and pours it out.
So notice that they're now gonna she's gonna take the liquor bottle. You heard her, it's twisting the cap. You're gonna hear her break the seal on it.
That was the sound of the seal on the liquor bottle breaking. Here's another angle. While Officer Muth questions Riley about marijuana
Did
again,
somebody else smoke in your car earlier?
Oliver tosses the empty bottle into the passenger seat. They don't find any marijuana in the car. Here's Officer Oliver implying to Officer Muth that the empty bottle was likely what was in a cup in Riley's center console.
Cover where like the knee would sit. There's an opening, and he had it like tucked. Okay. And then the whatever he had in his cup also smelled.
Then Officer Muth tells a senior officer that they found open alcohol in the car,
That's
in both a
about what
bottle
happened
and a
with
cup.
Did y'all search the car? Yeah.
Okay, nothing in there.
Well, okay, so he had a bunch of alcohol stashed in there, but
Nothing open or anything.
yeah, open.
Oh, okay.
Yeah, in his like Tervis in the center console, he had a mixed drink, and then under his knee, he had a like little bottle of vodka tucked away.
Notice she talks about like she doesn't show any other bottles of vodka empty. Now, granted, we have to keep in mind this is a news reporter who has the video, the entire unredacted body cam video, and he's showing us clips. So you have to be careful that he's not being truthful. But notice she is already lied about a bunch of things. That they smell marijuana. That, oh yeah, there's alcohol in that cup. How do you know? She didn't go up to the cup and go, yeah, it smells like alcohol. Just listen to her. This is complete garbage.
When officers group to discuss the case, they all ask each other if their body cameras are off.
Still on. Any evidence of that?
Marijuana.
Yeah.
Are you still on?
The video ends at this point. Riley's arrest report states, quote, a search of Riley's vehicle yielded a small bottle of vodka that was opened in a pocket in the driver's seat cover. Riley's case begins on Friday, April 5th in the Leon County Courthouse.
So this is her affidavit, and she's saying this is all typed up, that they found this alcohol opened. Affidavit, and she's...
Oh, hi.
Hi, McKinley.
How are you?
I'm doing well. So, have you heard about this at all?
Yes, I did. I saw it early. Well, I
You
didn't
watched the
actually
civil rights
see the
lawyer
video.
guy?
Yeah, I saw
Yeah.
it on something.
Yeah, you probably saw it there.
I
Hold on a
think
second.
I didn't actually see the video. I just heard them talking about it.
So yeah, this is so now this guy went to trial today.
Oh, really?
Mm-hmm. And the channel that put this up, our Tallahassee, actually recorded it. I think they did it live actually.
Really?
So yeah.
Nice.
So at some point I'll probably watch that, but now we've got, instead of just that, we've got this beauty of a thing here. This is her deposition she gave. Apparently this is the second deposition.
Yes, this is the thing I saw.
Oh, you saw parts of this? Okay.
I saw parts of this.
Yeah.
This is good.
Yes. And yeah, here we go. I mean, and just by watching that stuff alone, she should be in prison right now. But sadly, that's not how this works. Well, how many people she lied about before, fabricated evidence on?
I know, right?
8 a.m. Their court reporter is Lisa Babcock. My name is Jeff Babcock. I'm the videographer. We're here on behalf of For the Record Reporting.
Now, guys, this is how a deposition starts. The people who are doing the recording indicate who they are. So that's why this is all starting out that way. You're going to hear everybody introduce themselves. So that way you understand who the voices are.
Counsel for the parties, please introduce themselves, starting with the state attorney's office, and the court reporter will swear in the witness.
Emma Hershey, certified legal intern for the state.
Siobhan McCants, assistant state attorney.
Desiree Goodfellow for the defense.
John A. Toddman, assistant public defender.
And for the record, the defendant, Mr. Riley, is present today.
And you're going to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
Just a hair.
Are we good to begin? Cool. Could you please introduce yourself for the record and spell your last name?
I'm Officer Kiersten Oliver, Oliver.
Officer Oliver, what's your current position?
I'm a police officer at the Tallahassee Police Department
How long have you been with Tallahassee Police Department?
since 2020.
Now, I kind of want to talk about how you got into that position. What type of training did you receive to become an officer?
I did basic recruit training at the Pat Thomas Law Enforcement Academy.
Does the academy include any specific training as it relates to investigations?
Yes.
Can you tell us a little bit about that?
We do basic investigations as well as DUI investigation training.
What kind of training do you receive for DUIs?
Basic DUI refreshers and basic DUI training.
When we talk about basic training for DUIs, does that include things such as looking for signs of impairment?
Yes.
Now, once you completed the academy, you said that you started working in 2020?
Yes, ma'am.
So now I want to transition into your involvement in this case. Do you recall if you were on duty on May 7th of 2024?
Yes, ma'am, I was.
And specifically directing your attention to around 2 a.m. What were you doing at that time?
I was on a different traffic stop.
Can you tell us what specifically was going on during that traffic stop?
When I was on that traffic stop, I was back up for Officer Muth, and I observed a vehicle at a high rate of speed with no headlights on pass by me.
And just to clarify, so you're on a separate traffic stop, and as you're attending to that traffic stop, you notice an additional vehicle driving down the road.
Correct.
And can you tell us what specifically stood out to you about that vehicle driving down the road?
The high rate of speed and no headlights were visible.
What did that car look like?
It was a white sedan.
Once you see this vehicle driving with a high rate of speed and no headlights on, what's your initial reaction?
I made sure that Officer Muth was safe, and I got inside my marked patrol vehicle and went to initiate a stop on the vehicle that passed by me.
How long did it take for you to catch up to that vehicle?
Longer than average, but a few seconds.
Did you have to speed to catch up?
Yes.
Now, after you're speeding on the road, do you ever activate your emergency lights?
Yes.
Can you describe to us how that vehicle is driving at that point once your lights are activated?
It slows down, but it continues for a couple of blocks, and then it pulls over into a left turn lane.
And while it's slowing down and as it's driving through, did you notice anything in terms of driving patterns such as swerving?
Yes.
Can you tell us about what you observed?
Yes. So the vehicle was hovering lines on the right side of the road and the left side of the road, was engaging in the other lane that instead of the proper lane that he was in originally, or the vehicle was in originally, and then pulled over into the left side lane.
You stated that he was engaging with another lane as he was driving down the road. When he was breaching or moving towards that secondary lane, were there any other vehicles that could have been impacted?
Yes.
Can you tell us about that?
There was another vehicle in the lane, in the right lane, if you will, while we were in the left lane.
And just to clarify, are you saying that the vehicle that you were pursuing was
Objection
swerving?
leading.
I'm going to ask the question again. It's noted for the record. But just to clarify, are you saying that as the vehicle is swerving, that there's another vehicle that it almost went into?
Yes.
So after you stopped the vehicle, where were you? What county were you located in when you stopped this vehicle?
Leon County.
And where was the vehicle located in the roadway when you stopped it?
It was located in the left-hand turn lane.
Okay. I want to transition a few minutes forward. So you stopped the vehicle.
I do want to just comment on this, guys. Yes, keep this in mind. Her memory right now is absolutely flawless. Absolutely flawless memory. Here we go, guys.
Do you attempt to make contact with the driver of that vehicle at that point?
I do.
Okay. Can you tell us, as you're walking up to the vehicle, can you tell us what type of vehicle it is up close?
It's a white sedan, and as I get closer, I realize it's a Mercedes.
Were you able to determine who was driving this vehicle?
Yes.
And who was that?
That was the defendant.
And what was his name?
Mr. Calvin Riley.
Do you see the driver of that vehicle in this room here today?
I do.
Can you please identify him by article of clothing?
Black long sleeve t-shirt.
And let the record reflect that the witness has identified the defendant as the driver of the vehicle. Officer Oliver, do you see any other occupants in the vehicle as you're making contact with the defendant?
No, ma'am.
During this interaction, did you have a body-worn camera on?
I did.
Okay. Can you tell us whether or not that body-worn camera was activated during your interaction?
It was.
Okay. Would you recognize a copy of that if you were to be shown it here today?
Yes.
Okay. Let the record reflect that I'm showing both opposing counsel and the witness what has been pre-marked as State's Exhibit 1 for identification purposes. Officer Oliver, can you tell us what I've just handed you?
It's a copy of my body-worn camera from the traffic stop.
And just to clarify, did you have an opportunity to review the video footage on this disc?
Yes.
Okay. And the video footage on this disc, is that the same video from when you were interacting with the defendant on May 7th?
Yes.
Okay, thank you. Is it a fair and accurate copy?
Yes.
The state moves to enter what's been pre-marked as State's Exhibit 1 into evidence.
No objection. It's the same one from the previous hearing, correct?
Correct. Okay. Officer, I want to pause now for a moment and just talk a little bit about what your training was when you were an officer, or when you were going through the academy. Could you tell us what kind of symptoms you're trained to look for in a suspect when it comes to looking for signs of impairment for their face?
Yes. So for the face, it would be sweating.
Objection. Not DRE. Can't testify to this.
For the record, response to the objection is that this is within her personal knowledge. It does not require any scientific knowledge. Rather, it's just based on lay observations and opinions under Rule 701, which would be qualified based on her training and experience rather than anything scientific in nature. Therefore, she would be allowed to answer.
It would be sweating in the face, glossy eyes, bloodshot eyes, and possible odor from the mouth.
Okay. Now, when you make contact with the defendant, when you approach him, what's the first thing you notice about his face or his appearance?
I noticed that his eyes were glossy.
So as you're talking to him, you see that his eyes are glossy. Do you ask at any point to see any identification from him?
Yes.
And can you tell us a little bit about what his behavior was like as he was searching for his identification?
Yes. So I asked for his registration, proof of insurance, and driver's license. And while he was searching for any of those documents, it was fumbling. He looked in his center console, did not pull anything out, just stared into it. He pulled his visor down, papers were dropping, and he was trying to grab the papers out of the visor. He just seemed confused.
During that interaction, did he ever make eye contact with you?
Yes.
And also, additionally, as he's fumbling with these documents, searching for things, was he ever able to produce an ID for you?
No.
What was he able to produce?
A piece of paper with his name on it.
Did he tell you anything else about himself?
He gave me his name and date of birth.
Okay. So while you're speaking to the defendant, trying to get this information, can you tell us, what does the car smell like in that moment?
I believed at the time it possibly smelled like alcohol.
The car
Were you
smelled
100%
like
certain at
alcohol.
that point?
No.
Okay. Now I want to pause again. During the academy, did you ever receive any training to look for speech patterns?
Yes.
And can you tell us a little bit about what the defendant's speech was like that night?
It was
Objection relevant.
For the record, this is under Rule 401. This would be relevant because it goes to whether or not the defendant was impaired that night. Whether the defendant was slurring his words would directly go to whether or not his normal faculties were impaired. Therefore, it would be relevant, and it makes the material fact more or less likely.
So his speech was slurred.
Okay, so as you're hearing the defendant talk with slurred speech, does he ever mention anything to you about the headlights on his vehicle not being on?
He asked why I slowed him down, and I advised to him that he was traveling at a high rate of speed and that his headlights were off. And he asked me, am I sure? And I said yes.
And what was your reaction, or what, if anything, did you have to do to show him that these lights were in fact off?
I pointed his direction to the light switch that controls the headlights in the vehicle. I told him his parking lights were on, and then I turned it over again, and then the lights for the headlights appeared.
Is that the first time you saw the headlights on his vehicle?
No. Or can you rephrase that question?
Is that the first time his headlights on the vehicle were turned on in your entire involvement in this case?
Yes.
Okay. So after turning on the lights, at any point during your initial conversation with the defendant, did he indicate where he was coming from?
Yes.
Where did he say?
He said 429 West Brevard Street.
Were you able to determine who lived at that residence?
He did.
And did he mention anything about his brother?
Yes, he did. He said that his brother lived there.
And were you able to confirm were you able to confirm whether that was, or his brother also lived there?
No.
So I want to transition. It's late at night. The defendant's slurring his words. He's unable to
I think you
produce
should
an
be worried
ID.
about
At
him
that
telling
point,
lies.
did you ever try to attempt to verify his identity?
Yes.
Okay. Can you walk us through how you verified that?
Yes. So once he gave me his information and the piece of paper with his name on it, I went back to my patrol vehicle and looked into law enforcement resources, and I was able to confirm his identity with the information that he gave me.
And what, if anything, did you learn when you were verifying his identity?
I learned that his license was suspended.
Now, before today's trial, did you have an opportunity to review the defendant's certified driving record?
Yes.
For the record,
Objection was never put on the answer to discovery
and the answer to discovery was filed yesterday, and it was sent to you as well yesterday.
without proper notice.
It is, David. It's the deposition.
It's also important to note for record purposes, this is the first time that the state received this yesterday from the DMV. It was they provided it to the state yesterday. We requested it back in early February. Additionally, an answer to discovery was in fact filed. We made sure that this was sent to the defense yesterday afternoon via the portal. In addition to that, this is a public record that the defense absolutely had access to and they could have requested on their own in addition to that. However, the state has provided it, therefore it would be admissible in today's trial.
We will be asking for a Richardson hearing. For the record, it's a state agency. You've been in possession of it for the entirety of its existence.
This is not a law enforcement agency, therefore it wouldn't be assumed to be possession of the state. Only law enforcement agency documents are assumed to be in possession of the state. Therefore, the state is going to proceed with questioning and we can make an official ruling after the fact with the court. All right.
Okay, guys, so you see there's an issue when you have depositions and nobody can agree on the objection. Another party's like, they'll ask a question anyway, and then the court can rule on whether or not that question and the response were admissible. So they can say, yeah, that was a leading question, so that response isn't admissible. So they can literally cut that out and remove it. But this argument here, they can't go back and forth. Sometimes you say, well, I'm asking it anyway, deal with it. And the state's just getting all snippy and saying, well, we'll let the court handle it. You know, and that's where this is going right now. And Carrie, you asked a question here. I'm just going to ask this real quick. I don't understand why is this on trial exactly? Because the state's a bunch of assholes and they won't let it go. Because they think they can prove he's drunk regardless. I don't know. Because the prosecutors don't like dismissing cases. Is she being sued? Not yet, but I assume she will be if this guy wins. If he loses, he's toast. But if he wins, yeah, I'm assuming he's going to sue her for a 1983 violation. And yeah, it's going to be great watching her humming her way out of it. So, yeah. But yeah, let's keep going, guys. I know we're trying to get to the good part here because this is still all the basics.
Officer, I'm going to ask the question again. Before today's trial, did you have the opportunity to review the defendant's certified driving record?
Yes.
Okay. Would you recognize a copy of that if I showed it to you here today?
Yes.
For the record, I'm showing both the defense and the witness what's been pre-identified as State's Exhibit 2.
We're still objecting.
And now handing the witness. Officer, do you recognize what's been pre-identified as State's Exhibit 2?
Yes.
And can you tell us what this is?
This is an official driving record of Mr. Calvin Augusta Riley.
And where was this produced from?
The Florida Highway Safety and Motor Vehicles.
Now, I want to direct your attention to the last page. Could you tell us what this last page is discussing?
Yes.
Objection, hearsay.
This is for foundation purposes. It's the certification from the custodian. So it's for foundation purposes, and therefore it's not being offered for the truth.
And still objection, she's not the custodian of record.
Officer, I'm going to proceed with the questioning. Could you please clarify what is the last page of this document?
It says that it is a true and correct transcript of the above named subject's driving record.
Is this produced by the custodian of the record?
Yes.
Objection.
Grounds for objection?
She has no personal knowledge of that.
She's reviewed this document in advance. It's a business record. It has a custodian attached document. The rules of evidence do not require that the actual custodian comes in person if there is an attached certification and affidavit from the individual. Therefore, she would have personal knowledge because she has reviewed this previously.
There has not been a notice to the defense. Is it also your assertion that this is not hearsay because it doesn't actually go to the truth of the matter asserted?
The truth of the matter, this is being offered to show. This isn't being offered for the truth of the matter asserted. This is purely for foundation purposes to establish that this is a custodian affidavit, and that is purely what it's being offered for. That is not hearsay. It's for foundation purposes. It is standard to ask that question for laying the foundation in a hearsay, for anything that is hearsay related to a regularly conducted business activity, and therefore we will proceed with questioning, and the objection is noted for the record. Officer, I'll ask the question again. Could you please clarify what this last page is again?
Yes, it says it is a true and correct transcript of the above named subject's driving record.
Is this produced, or is this an affidavit from the custodian of that record?
Yes.
Now, officer, I also want to ask some additional questions. The information that is in this document, did you have access to this information before reviewing this document?
Yes.
Can you tell us where you had access to it?
In the law enforcement database that I used.
Is that law enforcement database known as David?
Yes.
And what specifically do you usually use David for?
So David is a database that has driver's license information as well as driving history, and it's used for identification purposes.
So, officer, is this the information you had access to on the night that you were investigating the defendant
Some of this, yes.
And did you review this information that evening too?
Yes.
The state moves to enter what's been pre-marked as State's Exhibit 2 into evidence as State's Exhibit 2.
Objection.
It's noted for the record. Additionally, I don't know if I entered it earlier just for purposes. The state also moves. Did we move to enter the body worn?
Yes.
Yes. Okay. Cool.
And just for clarification, that's with the edits per judge's orders.
I'm sorry.
Is that already with the edits per judge's orders?
We weren't. What? If this has edits.
Per judge's orders.
Oh, I don't think that one has been edited.
Then we'll need a properly edited one
Yeah,
pursuant judge's
sure.
orders.
That's fine. We'll plan on doing that. Okay. Okay, officer, I want to direct your attention to page 1. Who is this document listed for?
Calvin Augusta Riley.
And I want to direct your attention to the header that states residential address. What does the residential address say for the defendant?
429 West Brevard Street, Tallahassee, Florida, 32301.
Can you tell us what the significance of this address is to you?
Hey, Tom, just putting this out there for you. Somebody had a question about a good starter set of clubs. So
That was the address provided by Mr. Riley that night.
Now I want to direct your attention to page 4. Pointing your direction to the last entry on page 4.
they're going to get
Can you tell
through
us
it.
what that is?
We got to get
It's a
through it.
suspension.
And when did the suspension take place?
Objection. Hearsay.
It's noted for the record, assuming that this has already been entered, it would not be hearsay once it's been entered and approved by the court.
Do you mind asking the question again?
Yes. Can you tell us when the suspension, which, to clarify, pointing your direction to the first column for the last entry, when was the suspension effective?
February 13th of 2023.
When did the defendant receive notice of that suspension?
January 27th of 2023.
Where would notice have been sent?
429 West Brevard Street.
Now I'd like to direct your attention to page 2. Can you tell us what the first entry is for? Or sorry, page 5.
It is a suspension.
And when was that suspension effective?
March 13th of 2023.
When did the defendant receive notice of that suspension?
February 24th of 2023.
Where was the second suspension notice to?
429 West Brevard Street.
And to clarify, is that the defendant's address?
Yes.
Okay. Now, I would like to direct your attention to the third entry on page 5. Can you tell us what the third entry is?
A suspension.
When did that suspension take place?
It was effective March 22nd, 2023.
And when did the defendant receive notice of the third suspension?
March 7th of 2023.
And where was that notice sent to?
429 West Brevard Street.
Now, officer, referring to all three suspensions that we just discussed on, were all of those still effective or in effect when you stopped the defendant on May 7th, 2023?
Yes.
Did he, at that point, complete the requirements to satisfy the suspension according to the record?
No.
When did he complete the requirements?
May 26th of 2023.
And to clarify, how many days after the stop did that take place?
19.
Thank you.
May I say for just a minute?
Now, on transition to the second half of your investigation, after you look into your database and see the suspension, do you call any backup to the scene?
I do.
Who do you call?
Officer Muth.
And why did you call Officer Muth to the stand or to the scene?
Objection relevant.
Because you know to help me plan evidence.
It's relevant to not only the timeline of events, but also why Officer If I could just have a moment.
Yeah, well, if you don't know why it's relevant, then what?
As it pertains to relevance, relevance is a low bar. It goes to whether or not a material fact is made more or less likely. Officer Margaret Muth is called to the scene to conduct the DUI investigation, which is an integral part of this case, and also directly goes to the element of whether or not the defendant was impaired. Therefore, it would be relevant under Rule 401. Officer, I'm going to ask the question again. Why did you call Officer Margaret Muth to the scene?
To help me conduct a DUI investigation and officer safety.
Why would you feel the need to call another officer for officer safety?
Objection, relevance. It doesn't go to prove a material fact as to why she felt like she needed to be safe.
During the suppression hearing, or as a response for the record, during the suppression hearing, the defense asked questions about why the defendant specifically couldn't have his phone, why it took multiple people to escort him to the car. Based on that alone, this is relevant as it goes to why she behaved in a particular manner during their investigation, and a witness's credibility is always relevant in a proceeding.
Because he asked why you're fucking hassling him and why he knew this was bullshit. Now, this is the intern doing it, the certified legal intern. So she's making sure she's crossing all her T's and dotting all her I's, and she's laying all this foundation out. But she's all seen all this video, and she's still, the certified legal intern's like, I want to represent the state. It's like, okay.
Just as a response, I don't understand how this goes to witness credibility, and this is not the suppression hearing, this is trial. So I would argue that it is not relevant and does not go to any material fact, and none of those facts have been entered into evidence, so it should not be relevant, Your Honor. But you can go ahead and proceed with the question.
No objection, because based on your response, you're also suggesting that it's prejudicial with little to no probative value.
Yeah. So David, basically what happened is they pulled a guy over. She found a sealed bottle of alcohol with like the cap and the seal on it. She opens it up. You can hear the seal break, and she dumps it out. She throws the bottle back in the car and says, "Oh yeah, he has an open container in the car." And then there was like a cup sitting in the middle console. And she's like, "Oh, it smelled like alcohol," but she never smells it. So they have him up on a DUI case, and that DUI is still going to trial today. The guy went to trial today in Tallahassee on the DUI. And this is Officer McLiar Pants coming up to, testify in a deposition. So, yes, Miss Perjury Pants. I'm going to speed this up, guys, just a hair. Because I don't know how long it goes till we actually get to the part where it's good. So I kind of want to get into it, but we're going to go here for a bit.
So noisy.
Oh, yeah.
Officer, I'm
and
gonna move on.
A lot of whispering.
Yeah.
Okay. I'm going to move on. Was the defendant ultimately placed under arrest after Officer Muth came to the scene?
Yes.
And were you present during that arrest?
Yes.
Before the defendant was placed under arrest, did he make any statements about what he was doing that night?
Yes.
Can you tell us what those statements were?
He said that he had had 2 beers and smoked a little weed.
Now, I want to talk about the defendant's behavior after he's placed under arrest. Can you tell us, did you bring the defendant to a patrol vehicle after placing him under arrest?
Yes.
Can you tell us what his behavior was like as you were trying to bring him to that patrol vehicle?
He was obsessed with getting his phone, making a phone call, and closing his car door.
What was the tone of his voice during this conversation?
Panicked.
Panicked. He was angry.
Did you ever offer...
Sure he didn't want the cops dicking around on his stuff.
Okay, so you mentioned that the defendant seemed panicked when he was asking about his phone and having his car door shut.
Now, here's the thing, guys. We haven't seen the whole body cam video. So let's say he did say that. I had a couple of beers and I smoked some weed. That's enough for them to arrest him on suspicion of DUI. So if he really was dumb enough to say that, he could still go to trial and still lose. Just something to think about. Just something to think about here.
But have you heard that? Does he say that?
Well, she says he said that. But right now, we haven't seen the full body cam as part of the problem. The body cam that got released was heavily edited. So,
Oh, really?
yeah. Yeah. So we haven't seen the unedited body cam. And that's the thing. David's right. If he said he had 2 beers, she might get fired still, but he could still get convicted. But Mark is saying he didn't say that. And that's fine because right now we have no body camera footage to show that. And she's a fucking liar. So I can't trust her at all. So for right now, we don't know. But yes, if it right now it's just her word, I don't fucking believe her. But if they had body cam footage of that, then he's toast.
Yeah.
So Ronnie says, I didn't hear him say that. Yes, but remember, we have not seen the full video. The part we just watched earlier, guys, that is a reporter giving you excerpts from it. So just something to think about. But if he does have it, that's it. So let's get back to it though.
Did you ever offer to get his phone or anything of the sort for him in response?
Yes.
And specifically, why did you not obtain it in that moment?
For officer safety purposes.
And could you elaborate a little bit more as to what you mean by that?
Objection, relevance.
Yes, I'm a little white lady and he's a black guy. That's officer safety. He could beat the brakes off me and I couldn't stop him.
Their whispering is so loud.
Yeah, well, it's also I've turned it up a little bit, so.
Oh, okay.
That's
how many times did the defendant ask you to get the phone and shut his car door?
Multiple.
Objection, relevance.
As it goes to relevance, this is relevant because it goes to his state of mind and his impairment level. Asking multiple times for something is a known indicator of impairment, and it therefore would go to that element of DUI.
He asked for it multiple times.
Is asking questions like that multiple times something you're trying to look for when trying to spot signs of impairment?
Yes.
Is it also somebody who just doesn't
like you? Were you able
like
to get the defendant to the patrol vehicle eventually?
Yes.
Okay. Did you try to follow up with him about getting his phone and shutting his car door?
Yes.
Can you tell us a little bit about that?
I did obtain his phone. I brought it to the patrol car where he was in, and I kept requesting if he wanted to make a phone call. Did he want help making a phone call? And he would not respond to me.
What ended up happening to his vehicle?
It was towed.
Okay. Now I want to talk about a different topic now.
Can we just pause for 1 second? I just want to know if this is going to pick up. Because I just don't, while she's talking, I don't know if we can hear, like, if it's going to pick up, like, drown her out while she's talking.
It's not drowning.
Okay. Sorry for interruption.
I want to transition in topics. After the defendant is placed into the patrol vehicle, did you have any opportunity to search the defendant's vehicle?
Yes.
And can you tell us about what that search looked like?
Now we're getting to it, chat. Now we're getting to the good stuff. But remember those statements alone, if any of what she said is on body cam, then yeah, he's, I'm hoping the jury would say fuck her and throw it out because she fabricated evidence. But let's just say it was just those parts. He was acting slurry and he was weaving and all that. That would be enough to get a DUI conviction. But it's the rest of this that sinks her.
Like for you?
Yes. So I entered the vehicle through the open door and I searched multiple cavities in the front seat and the back seat.
Did you find anything in the vehicle of particular importance to your investigation?
Yes, I found a insulated cup that obtained liquid and in the center console in the cup holder. And I also
How do you know it was an intoxicating liquid? Did you smell it? Did you taste it? Did you test it with a testing strip? How do you know it's intoxicating liquid? They don't say.
obtained a liquor bottle from the seat cover pouch where the knees would go inside the vehicle in the driver's seat.
I want to break down what you just said, starting with the liquor bottle that you found. What kind of liquor bottle was this?
It was a bottle of yellowish liquid labeled vodka.
Was it labeled anything other than vodka when you looked at it?
It was vodka infused with cognac, and the
Ew.
brand was on it.
After
Ew,
you find this
that
bottle
smells
of liquor in the
nasty.
defendant's near the front seat of his vehicle, what do you do with it?
I pour it out
Why did you pour it out?
because number one, our policy to impound, you cannot have liquids. And at the time, my mindset was that I was going to be impounding it. And then also, if the vehicle was going to be moved by a relative, I was not going to have alcohol inside the vehicle at the time.
Is disposing of alcohol standard within your field for?
Objection, relevant. What's standard in the field is not relevant to this case.
I'll rephrase the question. Is it standard protocol for you as an officer in your investigation to withdraw or to dispose of alcohol that you
Yes.
find?
Objection, I still say relevant.
This directly goes as to why she decided to dump out the vehicle or dump out the liquor.
Because she doesn't let people
Again,
drive around
relevance
with
is
spilled
an
bottles.
extremely low bar. It's relevant to this proceeding. As we know in the previous hearing, there was many questions. The defense was told that they are allowed to cross-examine on this topic, why she decided to do that. In anticipation for that cross-examination, this witness has the ability to testify as to why she decided to do this and why this is standard within her field to do so. Therefore, it is absolutely relevant to this proceeding.
I just, for response, I argue that it's not relevant. And again, we're at trial, not a hearing before, and those, we have not yet cross-examined the witness. So credibility isn't an issue yet. Well, I mean, it's always an issue, but we haven't attacked her credibility yet, just for the record.
Yes, and just for the record, it still is always that issue. Therefore, a witness's credibility in this situation, even though the cross hasn't happened, it's still relevant. And relevance is an extremely low bar. Therefore, it is relevant to today's proceedings.
Just as a response, though, everything is not relevant just because it's a low bar, but you may answer the question.
Do you mind asking the question again?
Officer, is it standard within your investigation to dump out liquor that you may find in a vehicle?
Yes.
Okay. Now I want to talk about the second item that you found inside the vehicle. You also mentioned earlier that you found an insulated cup. Is that correct?
Correct.
Okay. And how were you able to determine what was in this cup? Or
When I picked it up, I smelled it and it smelled of alcohol.
okay. And where was it located when you found it?
It was in the cup holder in the center console.
And to clarify, would that be the cup holder directly next to where the defendant was sitting?
Yes.
Now, keep in mind, we haven't seen video footage of that. Remember, though, the reporter said that it doesn't happen. But remember, I don't know if it did or didn't. But given the way she handled the rest of this, I can't believe her.
Okay, so I want to switch gears again. After you search the vehicle, at any point does the defendant move from one patrol vehicle to another?
Yes.
Can you tell us what that process looked like for you?
Yes. Due to the behaviors of the defendant in the aggravated state that he was in, he's much larger than we are. And so for officer safety reasons, I called my sergeant to assist us in removing him from my vehicle to another marked patrol
do
vehicle.
your
You said
job.
that his behavior was part of the reason. Can you tell us a little bit more about what
There's
you mean
two
by
of
that?
you.
Yes. So he was hollering at Officer Muth and I. He seemed agitated and he even attempted to not get into the vehicle when we were trying.
Yes, because maybe he saw you dumping out alcohol from a sealed bottle and trying to frame him for DUI. Imagine that. He might want to kick your ass over that. Just saying, Officer Sugar Tits. Just saying, officer. Like, would you get mad if that happened? Or would you say, oh, thank you for your service, fellow blue brother? I'm sure everybody would get mad at that.
To put him in the vehicle the first time.
Was he cursing during this period of time?
I don't remember.
And did you mention, or you mentioned earlier that you had a call for backup?
Yes.
Who did you call?
My direct sergeant.
And who was that direct sergeant?
Sergeant Smith.
Okay. And okay. Now, during your entirety of the interactions you had with the defendant, can you tell us, did he smell of anything in particular?
Yes.
Can you tell us about that?
Yes. So I believed he reeked of alcohol.
Okay. And what did his vehicle smell like?
Alcohol and marijuana.
No further questions.
Oh,
Well, here we go, guys.
I love when they say that. Like nobody can test that out.
So, Officer Oliver, on May 7th, 2023, you pulled over a white Mercedes, correct?
Yes.
And you pulled the car over for failure to turn on headlights at night, is that right?
And speeding, yes.
Speeding, okay. And you were wearing a body-worn camera at the time of the incident.
Yes.
When the video comes on, he's already stopped?
No.
No.
When the video comes on, I'm still driving.
Okay. When you get out of the car, though, your camera is still on, correct?
Yes.
Okay. His left blinker was on, is that correct?
I don't remember.
Would viewing your body-worn camera footage from that night refresh your recollection?
Yes.
Are you okay with me just playing directly from Axon since I don't have a disc player currently?
No objection.
Well, look at her. Look at that. Look at that reaction of her. Guys, look at that chat. Holy cow. Does that look like somebody who's like, just look at that.
Oh, she had to take the deep breath.
Yeah, does she, guys, she looks like she's about to like
pass out.
Yeah, she does not look like she's in control right now. I think she knows what's coming. Has she said it was open yet? No, she didn't mention any of that.
Her body on camera from the beginning point, and I'll announce the end point.
Yes, this case went to trial today. Yep.
Final stop's gonna be Laura Lee and Monroe.
The record, I'm pausing it at the 59-second mark. After reviewing your body-worn camera footage, did Mr. Riley have his left blinker on?
Yes.
And that's because he got over to the left to stop for the traffic stop. Is that correct?
Yes.
And when he got over, he put the car in park?
Yes.
And once Mr. Riley stopped, you approached his left side?
Yes.
And that's the driver's side?
Yes.
You asked him for his license and registration?
Yes.
He let you know that he did not have his license on him?
No.
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 So that's your testimony here today?
Yes, he was looking for it.
But he let you know at some point during the stop that he did not have his license on him. Is that correct?
Yes.
Yes. And it was not later found in the car that night?
No.
Even after your extensive search?
No.
And you asked him about a wallet. Is that correct?
Correct.
And he let you know that he did not have one?
Yes.
And he let you know that he keeps his money in a bank?
Correct.
And he pays for things with his phone?
Yes.
And people can pay for things with their phones, correct?
Correct.
For example, Apple Pay is a thing now.
Correct.
But he did provide you with the registration for his car.
He handed me a piece of paper with his name on it.
Which was the registration for his car, correct?
I don't remember what exactly the paper was.
And then you continued to ask him questions, is that correct?
Correct.
But he stayed on topic?
Pretty much.
I kind of get the feeling I don't remember is going to happen a lot here, chat. So let's keep going.
When he did not have his license, he gave you his name?
Yes.
He told you it was Calvin Riley?
Yes.
He gave you his date of birth?
Yes.
And that's April 3rd, 1968?
I don't remember from knowledge, but yes.
He gave you his correct birthday?
Yes.
Correct? And Mr. Riley let you know that he thought his lights were automatically on when he drove?
Yes.
But you showed him that the switch for automatic lights was not on?
Correct.
So you switched it on for him?
Correct.
So when he drove, the lights would then automatically be on?
I don't remember if I turned them on or put them on auto, but they were on when I turned them on.
Right. So if he continued to drive, then his lights would automatically
Correct.
be on. And that's because the car had automatic lights.
I don't remember if it had an auto setting.
You don't remember if there was an auto setting?
No.
Did you not just testify seconds ago that you turned it on to the auto setting?
No, I said that I turned it on. I don't know if it was on the auto setting or just on.
No.
But a switch needed to be turned on to put the lights on, correct?
Correct.
And at some point you went back to your patrol vehicle?
Yes.
And you ran his information?
Yes.
Yes.
Came up with his correct
We're well
birthday?
aware. That's a shame.
Came up with his correct address?
Correct.
And that's 429 West Brevard Street?
Correct.
And you believe that he knew that his license was suspended, correct?
Correct.
You believe that's the reason why he didn't have his license?
Correct.
And you checked whether his license was suspended, correct?
Correct.
And on that, it confirmed that his address was 429 West Brevard Street.
Correct.
Yeah, I see that. And you testified earlier that notices were sent to that address. Is that correct?
Correct.
I am now presenting the witness, which has been pre-marked as State's Exhibit Number 2. Can you please show me where in this it says that it was sent to that address?
So notices are sent to whatever residential address is on there. So the residential address says 429 West Brevard Street.
But you did not mail those notices.
I did not personally know.
So can you show me where it specifically says that those specific notices were sent to that address?
The notices would be sent to residential address.
So you're assuming.
Correct.
So you testified based purely on an assumption.
Correct.
That's an assumption likely to be believed by a jury that the mail got to where it was going. Because
And you called Officer Muth as backup.
didn't they also, I mean, if I just heard them too, they also said, didn't he tell you he thought his license was suspended? Didn't they also say that he thought his license was suspended? They're almost admitting that, yeah, his license was suspended. So, there's good facts here. There's a lot of bad facts here, in my opinion, so far.
Yeah, but having a suspended license doesn't mean that you are.
No, it's not. But he was going to get arrested anyway because you can get
for
arrested for
sure.
that in Florida. It's
For
just the idea you're arguing about whether or not he was suspended. It sounds like he already admitted he was. So, like, I understand they're going to make her look like a piece of shit, but it's just like the jury's not necessarily going to be sympathetic to somebody driving around with a suspended license, usually.
Is that correct?
Correct.
Mm-hmm. And when she got there, you wanted her to ask Mr. Riley whether he still lived on that Brevard address.
Correct.
Mm-hmm. And you saw that notices were sent to Mr. Riley regarding the driver's license suspension.
Correct.
And you just assumed that was 429 West Brevard Street.
Correct.
So you didn't actually see the notices themselves, though.
No.
Didn't you say
so you
his
actually see the
trial is recorded?
What's that?
Didn't somebody ask if the trial's recorded? Didn't you say it was like streamed or something?
Yeah,
today?
it was streamed and recorded, but it's like 8 hours long, guys. It ended at like 6:45 Eastern time. Like, there's no, and they've just now started cross-examining her.
Okay.
And yes, she's breathing heavy now. Yeah, she's starting to. And here's the thing: there is a news story that recaps some of this. But let's say some of this said today in court was true. The lights were off. He admitted to drinking, and he admitted, I don't know about the minute coming home for being behind a bar or whatever, but he denied field sobriety test. All that's gonna, and they claim he was weaving. Okay, well, yeah, they're gonna charge him up on a DUI. But if that was all if they had all of that, why did she fabricate all the evidence? Like, I think a jury's gonna nullify just because of that. Because at some point the prosecutor's gonna have to say, sure, she lied and fabricated evidence, but we have it enough anyway. Like, I don't think the state is going to say that with a straight face. I wouldn't say as a prosecutor. The moment I found out she fabricated evidence, she's gone because now she's tainted. Because from now on, if she ever is involved in anything, she's completely fucking lying.
Yeah.
So
she'll never be able to testify.
Yeah. Well, never be able to testify. I mean, she should still go to prison. This is evidence tampering. I think it should be just like anything else. It's evidence tampering.
Yeah.
For the notices.
Obstructing justice, whatever you want to label
And not on
it.
a physical piece of paper, no.
You didn't see it on the screen either.
So.
The residential address on the screen was 429 West Brevard Street.
But you did not see the notices themselves.
Correct.
So you did not see a mailing address on the notice.
Objection asked and answered.
Yeah.
She didn't answer. She actually said something different. Not just a different answer. She said that she didn't see it on a physical piece of paper. I'm asking about on the screen.
On the screen, it stated that the notice was sent and the address that was on the driver's license was 429 West Brevard.
But you did not see an actual mailing address on the notice because you didn't see the notice itself.
Correct.
I'm representing the witness with state exhibit number 2. Does this properly reflect what you saw on David?
There is information on this that is also on David.
Okay. But you just assumed that something was sent there because that was the residential address.
Correct.
You didn't see something specifically saying this notice was sent to 429 West Brevard Street.
Not to my knowledge.
Okay, so when you called Officer Muth for backup, that's because you already suspected a DUI, correct?
Correct.
But you weren't 100% certain it was a DUI.
Correct.
In fact, at that point, you hadn't even smelled anything, correct?
I said that I believed that there was a smell of alcohol, but I needed another officer's opinion.
That's your testimony here today?
Correct.
I'll be showing the witness her body-worn camera. Okay. You had a body-worn camera on at that time, correct? When you were conversing with Officer Muth?
Correct.
Was it on?
Yes.
So it would have captured that conversation?
Yes.
Okay.
Objection to improper impeachment. For the record, there hasn't been an opportunity for the witness to be confronted and an opportunity to explain before presenting extrinsic evidence.
My apologies, I'll be getting to that. So during the conversation that was recorded on your body-worn camera, you told Officer Muth that you didn't smell anything, correct?
I don't believe I did. I believe I told her that I couldn't tell if it was the smell of alcohol.
That is your testimony here today.
Yes, to my knowledge.
I am now confronting the witness with her body-worn camera. I will start it at the 5-minute 43-second mark.
Amazing.
So we got you lying, sweetheart.
Mm-hmm.
Or my apologies, it'll be the 5:39, just so that we make sure we get everything. So I feel like I'm getting some indications, but I'm not 100% sure. I can't really smell anything right now. Do you think you can just talk to him? So when you had that conversation with Officer Muth, you said that you couldn't smell anything right now, correct?
I couldn't really smell anything.
So you didn't say you couldn't really smell alcohol.
I didn't specifically say alcohol, no.
No, but that's what you testified earlier.
Correct.
But you didn't smell anything at that point.
Couldn't really smell anything.
Also, during your previous testimony, you said that Mr. Riley told you that he had been smoking weed.
Yes.
When did that happen?
Can we move sidebar?
I mean, we can edit this out at any point.
It just for clarification purposes, it is in between the refusal and him being arrested.
He never says that he was
He
smoking.
does, we heard it. It's very low, but it's on there.
He repeatedly says he did not smoke.
It's
After
at
the
the
fact.
end, but when he got out of the car, it's very low.
I just wanted
it is on there.
I just wanted to make it
We
sure it
would
was.
like to hear that because we don't
Sure.
believe that.
That's-
we
That's
don't
fine.
believe
It's on video. I just wanted to make sure you're aware before we proceed with it on video and everything. That it is
Ooh.
right in the moment.
Shit up.
Okay, so apparently only the prosecutors can do the. We have special prosecutor ears. We could hear it. Oh wow. Does perjury apply for depositions? 100% it does. But remember, perjury is the hardest one of the hardest crimes to prove. You can just go, I'm just a big idiot. Oops. Also, they're never going to charge her for perjury. They're never going to charge her for perjury. They're not going to charge her for fabricating evidence. They're not going to do anything. She'll get a medal or promoted or do something. Charlie, keep hoping because nothing's going to happen to her. Much as we'd love it. Yes, the police and their magical weed smelling nose.
Always.
Mm-hmm. The only thing better is if they had
After
the
he
magical
says,
weed smelling
It's a
dog.
little bit of weed.
That'd be the only thing better.
Those are better.
Yeah, hold on. We gotta back up a hair, guys.
Hear that because we don't
Sure.
believe that.
That's-
We
That's
don't
fine.
believe that.
It's on video. I just wanted to make sure you're aware before we proceed with it on video and everything that it is right in the moment after he says.
2
No to the
beers and a
refusal.
little bit of weed is what he said.
Can you give me a timestamp?
It
I
was.
can show you. I don't know if that's allowed.
Do you know the individual timestamp?
Like by number,
would
no,
be-
but I know where it's
I
at.
can
It's at
tell
the
you.
very, very beginning when right before he's.
It would
put in
be right
handcuffs.
before. It would be right before 2:10:30 on Muth's body cam.
And is that okay? So that's the one on Muth's body cam.
Yeah, you can hear it on Muth's body camera.
So where is it on her body cam?
Well, she was standing next.
I'm
but
going to pause 1 second. We just have to proceed with the questions because if we are in trial, this probably wouldn't
Yeah.
be going back and forth. She just has to ask her question and we have to move on.
Right. I mean, this is
So
all going to get edited because that's how it works.
I'll just say.
But it didn't.
Yeah.
I think we can go.
Well, the raw deposition isn't edited, but the one for trial would.
9:55 a.m. We are off the record.
Oh, okay.
Yeah. Also, they took a break.
We are back on the record. The time is 10:03 a.m.
Earlier, you testified that Mr. Riley told you that he had 2 beers and weed. Is that correct?
Correct.
And when would that have happened?
Before he was stepping out of the vehicle and Officer Muth was speaking to him.
Were you right there?
Should we believe you?
So anything that Officer Muth would have heard, you would have also heard.
I can't testify to what Muth heard versus what I heard,
Mhm.
but I was standing next to her. Correct.
And you're saying that he said he smoked weed.
Correct.
Did Officer Muth have a body-worn camera on that day?
Correct.
Did she have it on during that interaction?
Yes.
Yes. If you saw her body-worn camera, would you be able to tell that that is an accurate representation?
Correct.
At this point, I'm showing the witness
Officer Moose body worn camera. It's the first video. Just impeachment. On the video, lack of personal knowledge. For the record purposes, this witness has never been shown this video specifically.
She could testify to her own self, though.
Not moving into evidence. Yes, but still, impeachment has to be something within their frame of knowledge.
She was there.
She hasn't seen the video.
Yeah.
Have you seen
She's
this
there.
video of Officer Moose's body worn camera?
No.
No.
Just for the record, you can impeach with anything.
Yeah.
It doesn't have to be something that the
Yeah,
person
that's
previously
the other
you're
point.
Recording them, and they didn't know they were being recorded, and now they can be impeached with it.
She's on camera. Do you recognize? She can authenticate it. Who is this on camera?
Me.
Me. Is this you talking? Yes. Do you have knowledge of this? Yes. Did you say these words? Yes. Was this the date? Yes. So the idea they're trying to keep that out, she's being impeached through multiple means now. So, little known fact. Yes, you can impeach with everything. Everything's impeachable. Use anything for impeachment. So, J-Rock, I hope you like that. The state is only objecting to camera stuff they clearly know. Yes, in the state's argument, you know what they're going to say? Gosh, golly, she might have lied, but he said enough things that they're claiming the rest of it's true. She lied about all this stuff, but everything else, we got a golly gee Willikers DUI conviction. He's DUI and a suspended license. He's the most dangerous person out on the street. So, well, no, that's what they're going to say. And I mean, yeah, that does sound bad when it's, yeah. You're driving, if this guy really was driving drunk on a suspended license, he is an asshole. J-Rock says, is this you? Oh, no, me? Yeah. So, yeah, just look at her face. She's like, oh, no.
So I would say you can proceed.
Give the volume all the way
I will. Just first. Is this the correct day and time of that interaction?
Correct.
And this is Officer Moose's body worn camera?
To my knowledge.
And you were right next to her?
Correct.
Were you on her right side or where were you?
I was on her right side.
Okay. I am playing for the witness, Officer Moose's body worn camera. Her first one, this is at the timestamp of 3:56, but the time of day stamp is 2:10:20. I'll play the volume all the way up.
Gross.
Just go ahead and face the car. My apologies. It's going to go slightly back. Correction, it will be 3:46 with the time of day stamp of 2:10:10.
Exercises?
Not really.
No.
I had 2 beers, and that's what it is.
Okay. Here, go ahead and step out of the vehicle for us.
Is it still your testimony here today that he said that he smoked weed?
Correct.
And that was a fair and accurate representation of what
Did
we
you
said?
hear that,
Yes.
Sean?
What's that?
Did you think that he said that he smoked weed?
Well, that's why I want to hear this back. Yeah, we need to
He
hear it
said
again.
that
I
he
was trying to
smoked
listen.
weed. Correct.
I heard it.
That's what it is.
Time of day stamp of 2:10:10.
Yeah.
Exercises?
Not really.
No.
I had 2 beers, and that's what it is.
Okay. Here, go ahead and step out of the vehicle for us.
Is it still your testimony here today that he said that he smoked weed?
Correct.
Even if he said he didn't smoke weed, it sounds like he said I had 2 beers.
Oh, he for sure said I had 2 beers.
And he said, and that's really it. That's what I heard. Well, guys, here's the deal. Saying no weed. Yeah, she's lying about a lot of shit, but saying 2 beers, that could be enough. I mean, that's part of the problem. He admits to a bunch of shit. I think he says that's about it or that's it. But it's hard to tell without actually having it in our hands.
I think that it can't be enough, and that's why they're having to say the weed thing, right? Because like the combination.
I mean, like how long ago do you have the 2 beers?
I don't know, but 2 beers, I don't think puts you over 0.08.
It might.
Maybe.
Because also he's going to say, well, he's lying about how much he had because they're going to say, oh, he was swerving and weaving and all that. But now it comes down to credibility issues. And David says, so he might be going down for DUI. You don't talk to the fucking cops. Exactly. Don't talk to them. And maybe all they have is fabricated evidence and then you walk. So
Right.
let's just keep going here.
And that was a fair and accurate representation of what was said.
Yes.
Now, when you were next to the car, you smelled marijuana from the car. Is that correct?
Correct.
And that's one of the things that tipped you off to a DUI?
Correct.
Because it was a strong odor?
It wasn't strong, but I can remember smelling it.
It wasn't a strong odor, but you
Even though when you
smelled
called for Moose, you said that you couldn't smell anything at that point.
Really smell anything at that point.
So you arrested Mr. Riley for the offense of driving while license suspended or revoked, correct?
I did not arrest him for anything.
You were not the one who put him in handcuffs?
I think I put his right hand in a handcuff, but I did not make the arrest. I assisted in putting handcuffs on.
Okay, you didn't arrest him, you just put handcuffs on him.
Correct.
Okay.
But prior to that, you discussed with Officer Muth about whether you should arrest him, correct?
Whether the arrest was to be made, correct.
And at that point, you already knew that you were going to arrest him for DUI.
That wasn't my decision.
That wasn't your decision.
No, it was Officer Muth's.
Not your decision?
Did you not discuss it with Officer Muth?
I discussed whether she was going to arrest him for DUI, correct.
So it really, at that point, when he was arrested, it was for driving while license suspended or revoked and DUI.
Can I testify to Officer Muth's judgment on that?
So you had no decision making at all. Is that what you're saying?
I can give her my basis for investigation and what I perceived and observed, but she made the ultimate decision.
Now, after Mr. Riley was arrested, you searched the car. Is that correct?
Correct.
Prior to the search, you put on gloves?
Correct.
And that's just standard procedure?
Correct.
And that's because you don't want to contaminate any evidence?
Or get anything on myself, correct.
Right. It's also a safety measure.
Yes.
During that search, you found a bottle of alcohol?
Correct.
And that was found in a pouch on the front of the driver's seat?
Correct.
I think you said earlier it would be if the driver was sitting behind their calves, behind their knees. Is that right?
Yeah, behind the knees area.
And the bottle you found in that pouch was the 20 grand vodka, correct?
Correct.
And it was a smaller bottle?
Correct.
But bigger than the ones you get on planes?
Yes.
And the bottle was a twist top?
Correct.
When you found the bottle, you took it out of the pouch?
Correct.
And then you put the bottle on the seat?
Yes.
And you continue then to search the car?
Correct.
As part of that search, you opened containers you found in the car, correct?
Correct.
During that search, you didn't find any marijuana?
No.
You didn't find any joints?
No.
You didn't find any paraphernalia?
Wait, how do they say?
You didn't find any marijuana? You opened containers?
Yes.
And you continue then to search the car?
Correct.
As part of that search, you opened containers you found in the car, correct?
Oh, she opened containers. Okay.
During that search, you didn't find any marijuana?
No.
You didn't find any joints?
No.
You didn't find any paraphernalia?
No.
You didn't find any evidence of marijuana besides the smell?
Correct.
Before finishing the search, you went back to that 20 grand bottle that you left on the driver's seat?
Correct.
And you picked up that bottle?
Yes.
You opened that bottle?
Correct.
That bottle was sealed before you opened it?
Yes.
And so you twisted the top of the bottle?
Yes.
And you broke the seal?
Correct.
And you, after you opened it, you dumped out the contents?
Correct.
You dumped it onto the road?
Correct.
Then you put the top back on the bottle?
Yes.
Then you put the bottle back into the car?
Yes.
You threw it on the passenger side?
Yes.
Earlier you said that was just standard protocol?
Correct.
For what?
So you usually unseal alcohol bottles and dump them out?
Typically, I don't unseal them, but as I was twisting, I realized it was unopened, and that was my fault.
And has that always been your testimony?
No.
No, but previously you said that you didn't unseal it.
Correct. I didn't believe I did.
But now you know that you did unseal it.
Yes, watching my body camera.
Yes, my testimony was wrong. I was mistaken. I wasn't lying. I'm just oopsie poopsie.
I didn't know I was caught on camera.
Yeah, I didn't know you guys caught me committing a felony. Uh-oh. Uh-oh. Uh-oh, chat. Whoopsie. Yeah. Oopsie poopsie. Whoops-a-doodle. You know, we've all been there before.
Now,
Just
also
look at her reaction again.
And has that always been your testimony?
No.
No, but previously you said that you didn't unseal it.
Correct. I didn't believe I did.
But now you...
Notice she's not even like, oh my God, I messed up. She's just stone faced.
You know that you did unseal it.
Yes, watching my body camera.
Professional liar.
Now, Officer
Kiersten
Muth was
Oliver.
the other officer with you, correct?
Correct.
She also conducted the search of the vehicle?
I don't remember if she searched the vehicle. I just remember myself searching the vehicle.
Okay, so you don't remember her searching on the passenger side while you searched on the driver's side?
No, I don't remember that.
Okay. But you did tell her about it, correct?
Correct.
Because you were the one who actually found the bottle.
Correct.
And officers rely on each other to write reports.
Yes.
And that's because not every officer sees everything.
Yes.
And not every officer writes a report.
Correct.
Usually there's a primary officer.
Mhm.
Correct.
And they're the ones who write the primary report.
Correct.
Other officers can write supplements, though. That's pretty normal.
Correct.
You wrote a supplement.
Correct.
In this case, Officer Muth was the officer who wrote the primary report.
Yes.
Like you said, she really made all the decisions.
Correct.
And you told Officer Muth about the bottle.
Correct.
And you told her that because she was the primary officer.
Yes.
Because she'd be writing the report.
Correct.
And you told her about the bottle because it was evidence.
Correct.
An open liquor bottle found inside the car within reach of the driver would be pretty big evidence with DUI, right?
I'm sorry, I didn't understand that.
Which was the last one that you understood?
Okay. That also happens a lot during depositions, guys, doors opening and closing, things like that. That does happen. That's the live TV aspect of it.
Because she was the primary officer.
And what was the one right before that?
And you told Officer Muth about the bottle. Answer correct. Question, you told her that because she was the primary officer.
And you told her about the bottle because it was evidence.
Correct.
An open liquor bottle found inside the car within reach of the driver would be big evidence for a DUI, right?
Correct.
And you told Officer Muth that the bottle was open?
I don't remember my exact phrasing, but I know that from seeing her report, she said it was opened.
And she would only know that from you?
Correct.
And like you said, she put that in her report.
Correct.
Because the empty bottle was evidence of DUI.
Can you say that again?
So the empty bottle, that was evidence of DUI at this point, correct?
Correct.
But the contents would really be the evidence of the DUI?
Could be, correct.
But you dumped it out?
Correct.
Despite it being evidence?
Yes.
Correct. What is
Brilliant
the
work.
protocol that told you to unseal a liquor bottle and dump it out?
I'm unable to impound liquids into our police department property and evidence. And at that time, I believed I was going to be impounding it. So I dumped it out.
And so what is the authority for impoundment? The rule. Where do you get the protocol rules for impoundment?
Our general orders, and I believe this was General Order 42.
So that would be the standard protocol.
Yes.
If I showed you a copy of General Order 42, would you be able to recognize it?
Yes.
Uh-oh. Oh, I'm assuming it doesn't say what it says. Uh-oh, chat.
So is that a copy of General Order 42?
Yes.
Can you please show me where in there it says that you cannot impound a sealed bottle of liquid?
That would take me forever to look through. Do you want me to do that?
Or if you can just show me where
Objection,
it's
improper
regarding.
impeachment.
Oh my God. I love that.
Do you not remember?
I love that. It's like, oh my God, it'd take me forever to look. You know what the attorney said? That's okay. I've got time. Take your time. Read it. I'm sure I've read police department's impound policies. They're not that long. There might be like, 8, 9 pages, but it's not like 9 pages, like single spaced. Like there's a lot of bullet points. It's not hard. She's making excuses. So that's all she's doing here.
I don't remember the exact placement now.
If you saw the order, would you be able to recall?
Recall that it was in here? Yes.
Okay. Can you look through it and then tell me if you see it?
Objection, improper refreshment.
It's not
She said she didn't remember.
Yeah, so she doesn't remember. Now, I think what she's trying to say is show me exactly where it's at. Now, the point is it doesn't exist. So now they're kind of impeaching her through trying to refresh her recollection. But I get they're trying to say, like, you can't make her read the whole thing. But yeah, read the whole fucking thing. Yes, objection. She's making my client read.
So with reviewing that, refresh recollection of where in the report or where in the rules it says you can do that.
That I can dump it out or that I can't impound
Let's
liquid?
go first with the impoundment issue.
Okay, so impounding liquid, correct.
Mm-hmm.
That would refresh. Specifically alcohol, I don't.
No. So looking at this, though, would tell you where the protocol is that you can't impound liquids.
Correct.
Is that correct? Well, here it is. Read through it and then please let me know when you found the part.
Does this include the property and evidence packaging manual?
Can you be more specific about that?
So the authority related references, it has the property and evidence packaging manual. Is that included in this?
I believe so. That's procedure 17.
Oh, she was trying to get him on that as a gotcha. But they're like, yep, it's there too. Oh, shit.
Almost like she's been studying for this.
Yeah, well, I'm sure they've been her buddies have been teaching her how to lie. They call it test-a-lying. And they think it's hilarious that they do it. They actually fucking joke about it, chat.
Wow, that's real gross.
For the record and for defense counsel, for efficiency purposes, are you able to direct where in this document you would like her to look?
Well,
for liquids?
The issue is it's not protocol.
I understand. However, this is a 33-page document. This would be an extreme waste of time to have her flip through each and every page. So if there's a particular section you would like her to look at in particular about that, about liquids being impounded, period.
The section
for
she thinks
efficiency
that
purposes,
it's
the
in.
state would object otherwise.
Yeah.
I don't think it's an efficiency issue to actually clarify whether or not there's a protocol, especially since it's such an integral issue to this case. I can give you the page number for section 17.
Mm-hmm.
1 second.
So they're going to point out it's not true.
Page 32 is the property and evidence packaging manual and supplies that you were
Pulling Ethan
referencing.
Ralph. That's not true.
But it's not actually the manual.
No, but there is a portion about impoundment protocols, correct? In other parts of this general order, there's multiple.
About impounding, correct.
And about also disposal of evidence.
Correct. Possibly. I don't know because I haven't read the whole thing recently.
Had you read it recently at the point that this case happened?
The protocol was directed out to me through use of another law enforcement officer. So they directed me to it in the general order, and I read it.
On that day?
On the rest
May
day?
7th?
No.
After when it wasn't really relevant.
Yeah.
So I see where this is not the actual copy of the manual, but there is a copy of the manual to be seen.
That doesn't make any sense, lady.
Yeah. It's well.
Page
She's a cop
7.
lying, and that makes sense to her.
Section 2 deals with just general protocols for impoundment. Page 8 has packaging and transfer specifically regarding liquids. Could you review that passage?
On page 7 or?
It begins on page 7, but really the point of interest is page 8, subsection 8.
Okay.
Under packaging and transfer.
Okay, so you specifically want me to look at those areas instead of the entire 33 pages?
Yes.
She's like, she looked over. I'm like, help me. Help me.
So it says
She's
here,
like, didn't say many. You said general orders, actually.
all seized, recovered, abandoned, found, suspicious, and evidentiary property shall be logged into and placed under the control of the PME, which is Property and Evidence Unit, prior to the end of a member's tour of duty, except.
Objection hearsay.
Okay. Also, I was referring you to subsection 8. I think that's the next page.
The state would have re-raised.
Oh, I'm just refreshing her recollection at this point.
I understand. However, refreshing recollection does not require to be read onto the record.
Didn't ask her to.
I'm sorry?
I didn't ask her to.
Okay. Well, either way, objection hearsay.
That is a brilliant point. She was not asked to read it aloud. She read it aloud on her own. Now, court would say stop, but at that point, once there's an objection. But yeah, she wasn't asked to do that. She voluntarily did it.
Dumbass.
Yeah, she's like, what? What'd I do? Did I break the law, boss?
Look at her face.
Am
Oh.
I in trouble?
Okay, so you asked where it says not to impound liquid. What items would be liquid? So in here it says what items. Did you want me to read that?
No, like I said, page 8, subsection E.
Okay, you said page 7 through page 8.
Well, it starts in page 7.
Okay, subsection
Can we
E.
re-clarify what the question is? 'Cause I think we're lost as far as what the question is at this point.
I'm trying to figure out where the protocol is to dump out sealed containers of liquid.
Okay, I apologize. I thought the question was, where does it say I cannot impound liquid? And that would be on page 7.
You don't know what
So
they're
you
talking
can't
about, sweetheart.
impound liquid, period. That's what you're saying.
Correct. I cannot impound liquid.
Says who?
But liquids can be impounded.
Not by a standard patrol officer.
So if you find liquid, you're supposed to notify someone else to come in and pound it.
Correct, in certain circumstances.
If there's evidence.
Correct.
Because you're supposed to impound evidence.
Correct.
And this bottle was evidence, correct?
Correct.
So you
why
should have
keep her out?
notified somebody to come in and pound it.
So in certain circumstances, the forensics team would come out, but in a misdemeanor, they do not come out for liquid or for I don't know their exact protocols, but I know they don't come out for.
So you just made the decision.
Correct.
I don't know their
You
protocol.
just made the decision
but I
to
know
dump it
that.
out.
Yes.
And that's because you can't impound it.
Objection asked and answered.
Okay. In the car, you also found a insulated mug, right?
Correct.
And that was in the cup holder.
Now, uh-oh.
And it was in the cup holder at that point, correct?
Yes.
And you smelled alcohol in the cup.
Correct.
You thought it smelled very strong.
Correct.
But you didn't test the contents of the cup.
No.
You didn't take a taste of the cup.
No.
And you didn't dump out the contents of the cup.
No.
But that was liquid.
During the search, you found a bottle of cologne.
Yeah.
I don't remember.
Was in your body worn camera refresh your recollection?
Sure.
Objection, relevance.
It's relevant, something she found in his car.
I'm going to objection relevance as to what element does it go to for the charges, and additionally, it would be.
It's a liquid.
No, you asked about smell. This is a smell issue.
For cologne, nothing
Oh,
involving
it's
around
actually,
cologne was
yeah.
mentioned in her testimony.
No, it's a smell issue. If you,
It's fine. We can move on.
Y'all agree?
It's noted for the record.
For the record, response for defense. It came up that the officer searched the vehicle just for completeness purposes. We would argue that we would like to talk about the cologne that goes to smell, which we are questioning the officer on.
And just to clarify for state purposes, is an objection to relevance. It's not relevant to prove a material fact at issue in this case.
Are they trying to bolster their own witness?
Response.
I think
stated
so.
Before relevance is a little boring. We believe that this is relevant. You may proceed.
just to.
Real quick,
Oh.
is it going to bother my mic if I fan myself? I'm sorry.
I can get you a fan if you need.
No,
Do you want to step into the air conditioning for a
Oh,
minute?
she's
it's okay.
Somebody getting nervous. Oh, I know what they're trying to do here. They're going to say, okay, what was the smell? You didn't dump out how do you know it wasn't the cologne you were smelling? It could have been real shitty cologne. Also, they point out you didn't dump out the cologne. So were you really following rules?
That's why she's getting
Yeah, she's
concerned.
getting a little nervous. She's getting the vapors, yes. Yes, so. The cologne was musk because she didn't want the male cops to get turned on, so she poured it out. Yes. Do you feel like you're in charge, Officer Oliver?
As long as this is not going to bother anybody or my testimony.
Not like look at her looking at the camera like that's a side eye right there. But if you're watching this, you just see somebody start doing this. It's like they look like they're lying.
Okay.
Although it's also March in Florida. It's gonna get hot.
She looked like she was saying, "Please save me."
Yeah, that too.
So Would watching your body-worn camera while you searched refresh your recollection?
Yes.
I'm playing her body-worn camera at the 15:30 minute mark.
I don't know. It smells very strong. This is cologne right here, though. It's like sprayed it like right before.
So she admits that the cologne. Oh, so you admit there's a smell in the car. Now she's gonna try to claim, well, he was masking it. I'm sure is her answer at some point. But even the prosecutors didn't bring that up, which I think is a little. They didn't bring any of this up, which I think is a little telling. They know they got a shit case because they would have tried to explain some of this ahead of time, at least in my opinion.
Yeah, and didn't she say earlier I couldn't really smell? And wasn't she trying to imply that meant that she couldn't really smell anything? Because, like,
well, I think she couldn't tell what smell was what, and that's fine too. But that means you can't smell,
right?
So
Weirdo.
yeah, well, liar is what this is. Not a weirdo, scumbag.
Liar.
This woman could pull you over at gunpoint if she wants to. Still,
Having reviewed your body-worn camera, did you find a bottle of cologne in Mr. Riley's car?
According to my statement, yes.
And you smelled it before you even found it, is that correct?
I couldn't tell what I said there, but I remember hearing something about the smell of cologne. Correct.
And you stated that it was strong, the smell.
In the statement, yes.
And so you thought he had
strong.
sprayed a lot of it.
I believe I said that it smelled like he sprayed it right before.
So right before you came up to the door is what you're suggesting?
I don't remember what my thought process was behind the statement.
But you remember
I have a
that
feeling
the
that's
smell
not
of
an
cologne
uncommon
was strong
situation.
while you were searching the car.
According to my camera, correct.
And as we keep reiterating, you had your body-worn camera on during this entire interaction, correct?
Correct.
Oh no, we're gonna do this again.
It's a policy of TPD to have body cameras on during criminal investigations, correct?
Correct.
This was a criminal investigation,
Correct.
but you didn't have it on for the entirety of the investigation, correct?
I did.
So that's your testimony here today that you had it on for the entirety of the investigation.
I believe I did. I only have one body camera.
Uh-oh.
So you did not turn your body-worn camera off at 2:37 a.m. on May 7th, 2023.
I may have. I don't know the exact time of when I turned it off.
Would
have been whenever I was done with custody.
So when you would have been done with everything on the scene, custody of everything?
But that's
Except for
not
the
true.
tow, correct.
They
So
turned.
towing is in custody?
It was just towing his vehicle. I wasn't making contact with the defendant anymore.
But after you turned off your camera, you were still speaking with Officer Muth and Sergeant Smith about the case, correct?
I don't remember the conversation. It was over a year ago.
So you don't remember discussing indicators of impairment that you saw in Mr. Riley?
I don't remember discussing that now. But I could have. I don't know.
But your body-worn camera was off at that point.
Objection asked and answered.
I haven't asked that yet. So your body-worn camera would have been off at that point?
If things were discussed after I turned my body camera off, then yes, my body camera would have been off.
Did Officer Muth or Sergeant Smith ever convey you that their body-worn camera was on after you had turned yours off?
I don't remember.
No, they didn't.
So after you turned off your camera, you went to deal with Mr. Riley's car, correct? And that was because it was going to be towed.
Correct.
And you're careful when it comes to towing a suspect's car, correct?
Correct. Anybody's car.
That's because it could be a liability if something happens.
Objection. Relevance.
It is relevant. It's what she did on the scene.
It's relevant to which all like.
It's
not relevant to any material fact in this case. What we're here to prove is whether or not the defendant was impaired, and has normal faculties impaired, and whether he had knowledge that his driver's license was suspended. What happened to his vehicle when it's being towed is not relevant to any of those things. He's not at scene. He's not talking. The vehicle is actively being towed by somebody completely unrelated to this case, and therefore it's not relevant to any material fact in this case.
We would argue that it is relevant Mr. Riley's car was searched, and now it's being told we believe that we can ask this question again, as stated before by the state. Relevance is a low bar. Everything can be relevant. We would argue
Yes,
that.
relevance
Well,
is a
I will amend my objection to also outside the scope. There was no
yes.
discussion.
Everything, almost everything, is relevant to a certain extent. There's always some relevancy, but it's how much and is there probative value. So yes, most things are relevant, but do they have probative value? So, but yeah, she's going to be forced to ask the questions anyway.
And other than her merely stating that his vehicle was towed, the discussion with law enforcement after the fact, in addition to what happened during the towing process, was never once discussed. So therefore, any discussion on this would also be outside the scope.
And the response would be that we talked about the vehicle. The vehicle has come up numerous times with direct and cross. We would argue that it is within the scope, and we can proceed with questions.
It's also relevant anytime that officers are handling evidence.
The objection will be noted for the record. You guys can go.
So you're careful when it comes to towing a suspect's car, correct?
Correct.
And that's because it could be a liability if something happened to a car on your watch.
If I am responsible for the car at the time, yes.
You even made sure that Officer Muth had on her body-worn camera when she spoke with Mr. Riley about towing his car.
I'm sorry, can you say that question again?
So you made sure that Officer Muth had on her body-worn camera when Officer Muth, spoke to Mr. Riley about towing his car.
I can't make another officer have their body-worn camera on, but I may have said something to her that I don't remember.
Yeah, just
about
double
keeping it
check.
on.
And that's just a precautionary measure?
Correct.
But you didn't have on your camera when you went to deal with Mr. Riley's car being towed?
No.
Earlier, when you were answering the state's questions, you mentioned that Mr. Riley's brother also lived at 429 West Brevard Street.
He mentioned that he was coming from his brother's and mentioned that address.
And you said that you couldn't verify that?
I didn't verify it.
Right. You didn't try to verify it, correct? No. I want to confirm.
Come on, let's get to the good stuff, guys. Now they're just messing around.
You doing okay?
It sounds like she's doing breathing exercises.
You want to crack the door for a second?
Come on, let's go, guys. They're probably speaking with Riley right now about other stuff they can get her on.
I know this might be a silly question, Officer Oliver, but you don't work with the Department of Highway Safety and Motor Vehicles, correct?
No.
No. And you're not a medical doctor?
No.
You're the police officer?
Correct.
Correct. And you're not a drug recognition expert?
No.
And Mr. Riley told you repeatedly that he didn't smoke weed, correct?
Correct.
What?
And that's really what upset him, correct?
I thought she said he
I
did.
don't know what was in his mind, but that was probably my perspective at the time. My thought process.
Also, it's very common for people to be upset when they're arrested.
Correct.
Yep. They got that in there.
Let's
listen to her.
And you're not a medical doctor?
No.
You're the police officer?
Correct.
Correct. And you're not a drug recognition expert?
No.
And Mr. Riley told you repeatedly that he didn't smoke weed, correct?
Correct.
And that's really what upset him, correct?
I don't know what was in his mind, but that was probably my perspective at the time. My thought process.
Also, it's very common for people to be upset when they're arrested.
Correct.
Right? It's a subset.
Correct.
That's not a weird thing.
No.
No, that's very normal. And someone speeding isn't alone an indicator of impairment, correct?
No.
Not everyone who's speeding is impaired.
No.
No. And someone not having their lights on alone is not an indicator of impairment, correct?
No.
Not everyone who fails to have their lights on at night is impaired.
Correct.
Right. Nothing further.
Officer, I want to start from the beginning of your investigation. When you first encountered the defendant, can you tell us what his vehicle was traveling like?
It was at a high rate of speed and with no headlights on.
I know that defense counsel just asked you about if these things taken alone could be construed as impairment. When you're looking to see whether somebody is impaired, are you just basing your decision on one thing alone at a time?
Objection. Bolstering, and also I would argue invading the province of the jury. Whether or not she believes Mr. Riley was impaired does not matter. It matters if the jury believes that he was impaired or not.
To clarify for the record, my question was not asking for an opinion as to whether she believes he was impaired. Rather, I was asking what she is basing her decision on, whether it's based on one individual factor as compared to the totality of the circumstances. Therefore, it would not be invading the province of the jury. And in addition,
no, guys, I was reading through the article real quick, reading through what she said. Apparently, she acknowledges she did not, she saw him driving by, and she claims he was going fast and his lights were off. But she was standing there talking to the other officer. They were doing something else. And then she got in her car to chase him. So, yeah, she says he was going, she visually estimated his speed. But if he was driving with his headlights off, that would be enough cause for her to stop him anyway.
to bolstering, this isn't bolstering, it's just
But given that she's a fucking liar, I can't trust her.
it's just what factors she considers in her investigation, which is standard protocol within her field. Therefore, it's not bolstering whatsoever. Rather, just giving the jury an insight as to what exactly she's looking for.
Oh, I agree, Trust Arian.
Is that the state specifically asked what she looks for when looking for indicators of impairment, and she does not determine impairment. The jury determines impairment. So for that reason, I state the same objections.
Yeah, that's a conclusion.
Officer Oliver, when you're investigating someone for DUI, are you considering only one factor, or are you considering multiple factors?
The totality of the circumstances, which is all the factors together.
Okay. So would you have considered things beyond the speeding and the lack of headlights?
Objection, speculation.
This witness, for the record, this witness would have personal knowledge as it was her own mindset. Therefore, it wouldn't be diving into anyone else's mindset. So based on
yeah, but you're asking her to hypothesize on other stuff that didn't happen.
Speculation is also not relevant to what she looks for in other situations that are not this one.
Yeah.
Do you mind asking that again?
Yes. And also, just one last time for the record, it's not asking about other investigations, it's asking about in this particular investigation.
But that's not what she did in this
Officer
investigation.
Oliver, in your investigation in this case, after noticing the headlights off and also the speeding, did you look for other signs of impairment or indicators of impairment before calling Officer Muth to the scene?
Yes.
And what were those extra indicators that you saw or noticed?
Slurred speech and watery, glossy eyes and confusion.
And can you elaborate a little bit further on what you mean by confusion?
Confusion, like fumbling with the documents, trying to give me his identification.
Okay. Speaking of identification, I want to move on to another point that the defense talked about with you. Previously in your cross-examination, they mentioned that you did not review any notices sent to the defendant about the suspension of his license.
Correct.
Okay. So with that being said, is it your job to mail out notices to the defendant or other individuals?
No.
Is it your job to review the notices specifically?
No.
Okay. What's your job when you're investigating someone for that type of a thing?
So for that particular crime, driving without a license, it would be to either determine knowledge or no knowledge of that suspension, revocation, whatever the case may be.
Okay. And how do you go about doing that?
Using David as an example, you can see at the top of the page under the person's information, it will tell you whether or not it's been suspended, the date that it's been suspended, and then whether it's chargeable or not. I don't rely on just the chargeable or not. Like if it says chargeable, I don't always rely on that. I like to do a little bit more research into the history of driving. So I look to see if the driver states or there's proof that the address that they provided or is provided is the same address that the notice was sent to.
Okay, so when you're looking in the system for this case to see whether the defendant had notice, were you able to determine if notice was sent?
Objection, lack of personal knowledge.
For the record purposes, this witness has just indicated in her testimony that she did review the records and that the records indicated that a notice was in fact sent. Therefore, it would be within the personal knowledge of this witness and she would be allowed to testify about it.
Response, she looked off of the Florida Department of Highway and Motor Vehicles paperwork and stated that it was sent. That is not personal knowledge, just for the record, but you may proceed.
Did you have any indication in your system that notice was sent by the Department of the DHSMV?
Yes, it says that a notification was sent.
Okay, and I'm handing the witness what's already been entered as State's Exhibit 2. Could I direct your attention to page 2 of 7? Officer, under this section, it's towards the bottom of the paper, it states sanction information. Could you read the first sentence after that header?
Objection, best evidence is the paper.
Yeah, it's the best evidence objection.
This is the state moves to publish this, so therefore it can be published in this manner to the jury as well.
The first sentence says sanction information. Notices are mailed to the last address provided to our agency pursuant to section 322.251 Florida statute.
Okay, now before that specific sentence, are there any symbols right before notices?
Yes.
What is the symbol?
It's a asterisk.
Okay.
A little star.
Now, can I direct your attention to page 4 and 5, or starting from page 4? When you look at the columns and it says notice provided date, is there an asterisk there as well?
Yes.
Okay. So what was the address on file for the defendant according to the DHSMV?
429 West Brevard Street.
To your knowledge, was there any other address in their system?
Objection, lack of personal knowledge. She doesn't know what all is in their system. She doesn't work for the DHSMV.
Okay. I'll rephrase the question. In this document, is there anything in this document that says a address other than the Brevard Street?
No.
When you checked your system in David, and while you were still in your police car at the scene of the crime, did you see anything related to an address other than West Brevard Street?
Objection, speculation. She just testified that this incident was from over a year ago. How does she know what was in her system in David over a year ago, and if she was looking for other addresses at that time?
The witness has the ability to testify whether or not she has knowledge of that. It's not speculation if it is within the purview of their knowledge, and the witness has the ability to say whether or not she does remember or not. Therefore, it is not speculation.
Objection. I would ask then for those questions that relate specifically to her knowledge of things at that time for Exhibit 2 to be removed from her purview as it does not accurately reflect what was in the system on May 7th, 2023.
The witness has previously testified that this information is within the same information that she had access to.
You can proceed with the question. Just noted.
No, objection. She's also testified that there's information that was after May 7th, 2023.
The only information that's been referred to or published at this point has been to the information that was available to her. We're going to note the objection for the record. We can discuss it with the court. For now, in the meantime, Officer Oliver, I'm going to ask the question again. At any point in your investigation, when you're looking into David or the records of the defendant at that time, did you see anything other than a West Brevard Street address?
Not that I remember.
Did the defendant tell you anything other than a West Brevard Street address?
Objection, speculation, and he wasn't asked.
Again, speculation for the record is diving into the mindset or thinking without it, about something not within the knowledge of the witness. That if this individual indicated that she would personally have knowledge of what statements the defendant made, therefore it would not be speculation whatsoever. She can testify to what she recalls.
I would also argue, commenting on his pre-arrest silence, he wasn't ever asked this and before Miranda or afterwards, like if he changed his address.
Miranda does not apply to booking questions. So when it comes to addresses, it would not be within the scope of the right to remain silent in Miranda. Additionally, on top of that, when she did ask the defendant where he was coming from, he gave an address of West Brevard Street. He said additional things relating to his address. He attempted to produce documentation relating to the address, to which he did not and could not do. Therefore, it is within this witness's personal knowledge. It's not commenting on his right to remain silent, as it does fall within a booking question. Additionally, it's not, or yep. So that's the grounds for our thing, but it is noted for the record.
I would just say as a response, this is not a booking question. This is a question that the officer did not ask Mr. Riley on the day of the alleged incident. So I would argue that it is a comment on his pre-arrest right to remain silent, and also it would be, he was never asked the question. So I just argue there's speculation to say that he never volunteered something that he was never asked.
You did spontaneously mention the address previously. However, I note your objection. I'm going to move on. Officer Oliver, at any point in your investigation, did you have any reason or evidence that indicated that the defendant lived anywhere other than West Brevard Street?
No.
I want to move on to some of the observations that the defense talked to you about. You previously, or the defense previously mentioned that you made a comment relating to you couldn't really smell anything. Could you elaborate a little bit further as to what you meant when you said that?
So when I walked up to the vehicle, it wasn't 100% apparent that the smell of alcohol was apparent to me. I wanted another officer's opinion.
And when you're
It's
making the
not
observation
apparent?
of not 100% knowing, is that
It
when
was
you're standing
apparent.
outside of the vehicle?
Yes.
Did it become more apparent to you when you began searching the vehicle?
Yes.
What specifically did you smell when you were searching the vehicle?
Alcohol and marijuana and apparently cologne.
And just to clarify, so you mentioned cologne. You could smell alcohol and marijuana even over the cologne smell. Objection, lay down.
Objection asked and answered.
Could you smell the marijuana smell and the alcohol smell over the cologne?
Yes.
Now, defense also talked to you a bit about protocol as it relates to how you impounded evidence in this case. Now, I know we talked a lot about the liquor bottle that was closed. Was there anything other than just this bottle of liquor that you found that smelled like alcohol?
Yes.
And what was that?
That was the container found in the cup holder.
Okay. Now, returning back to the bottle of liquor that you found, you mentioned earlier that there was a protocol in place. Is that correct?
Correct.
And what was the protocol that you were familiar with?
That I cannot impound liquids.
Now, defense counsel previously showed you a protocol for general order number 42. I'm going to hand that to you here now. I want to direct your attention to the section that states current revision. Could you tell us if that revision of the policy shown to you by the defense was the policy that was in place on May 7th, 2023?
No.
Okay. When was this one in place?
July 24th of 2023.
So what's discussed in this document may have been would it have been different from potentially from what?
Probably not, though.
I'm gonna ask the question again. So the policy that the defense pointed your attention to, is it possible that it was different on May 7th, 2023 from what you were handed?
Yes.
Speculation.
Yeah, she'd have.
Is it possible that it was different? She doesn't know.
Officer, can you tell us when this specific policy was put into place?
This was revised, or the original issue was July 15th of 1985.
And when was the revised? When was it revised?
July 24th, 2023.
Okay, and that's specific to the copy you have there, for that one.
Correct.
Additionally, I know you previously mentioned that there was potentially a manual that would be included with that. Did you see the manual that you're referring in that policy?
No.
So is there more to the policy for impounding evidence than what defense showed you?
Yes.
Okay. In that additional manual or in your knowledge, do you know if there is a policy that says you cannot keep liquids?
Yes.
Okay. Now, when it comes to impounding liquids, is that something you were trained on, not to impound liquids?
Correct.
Is that something that at any point during your investigation, I know there was 2 other officers there, were you ever told that you need to impound this liquid?
No.
Okay. Is that because it was within policy?
Correct.
Okay. Defense also asked you about testing the contents of the open container inside the vehicle. Officer, is it standard for you to test contents of an open container?
Objection. What standard is not relevant to this specific case?
It's been brought into relevancy has been, the door has been open as to the specific issue. Therefore, relevance is at issue now, and but it has been noted for the record. Officer, I'm going to ask the question again. Are you aware of whether or not you are required to test the contents of this cup?
No, I'm not required to, and I don't know of a device that would even test the contents that we would obtain on patrol.
Okay. Did you have any device in your possession that could test the contents of the?
So how do you know it was alcohol then?
The
You
open
don't
container?
know.
No.
So you see this open container in the vehicle in the center console. What do you do to try to determine whether or not this is alcohol in it?
I picked it up and smelled it.
And what did it smell like?
It smelled like alcohol.
Now I want to pause and I want to go back to the beginning of your investigation momentarily. The defense talked to you about a blinker. How long did it take before the defendant initiated his blinker?
Several blocks.
Okay. And when he's driving these several blocks without the blinker and everything, do you notice him swerving?
Yes.
Do you notice his lights on at that point?
Objection asked and answered.
Do you want me to just answer it? No, at this point his lights are not on.
Okay. Also, I know we talked a bit about the auto lights. When would auto lights be activated?
If the dial is turned to the word auto.
And specifically, what type of time of day would you normally see auto lights activated?
At night.
Okay. What time of day was this stop taken at?
2 a.m.
Okay. Was it light outside or was it dark?
It was dark.
Okay. So it was dark outside and the defendant didn't have his lights on. You stop him. At that point, were you able to show him that the lights were off?
Objection, compound question, and asked and answered.
I'll rephrase the question. Were you able to show him that the lights were off?
Yes.
And did he believe you that the lights were off?
No.
Okay. What did he say when you told him about the lights being off?
Are you sure?
So, officer, okay, so after your investigation, you were asked several questions about having your body-worn camera activated. Are you required under policy to keep your camera activated when you're not engaging with civilians or suspects?
No.
Okay. So when you were when the vehicle was being towed, were you in proximity to the defendant at that point?
No.
Were you having any interactions with the defendant?
No.
So based on your experience, would you have been required to have your camera on during the towing?
Objection, postering.
You may answer the question.
I'm sorry, can you ask the question again?
Would you have been required to have your camera on during the towing?
No.
Okay. Would you have been required to have your camera on during any discussions where the defendant wasn't present?
No.
Okay. No further questions.
Just want to clarify a few more things. You don't know Mr. Riley, is that correct?
Other than this incident, no.
Right. You never met him previously?
No.
No. So you don't know his normal faculties?
No.
You don't know how he regularly speaks?
No.
You don't know how he regularly walks?
No.
You don't even know how he regularly drives?
No.
You never asked him whether he knew his license was suspended, correct?
No, I did not.
No, because you just assumed so because he didn't have his license on him.
In the driving record.
And you said that you usually check where the notices are sent, correct?
Correct.
As part of your deeper investigation.
Yes, I verified the address with the notices, and then I know that Officer Muth also asked him.
But earlier you testified that you just assumed that the address that the notices were sent to were 429 West Brevard Street.
Yes.
So you didn't know for certain?
No, I'm going off of what David said.
Okay, so your deep dive was based on your assumption?
If you had said that, yes.
And you didn't ask if 429 West Brevard Street was where Mr. Riley got mail?
I did not ask that, no.
No. And you never asked him whether he received a notice?
No.
Have you previously testified that the protocol is to dump out open containers?
I don't remember.
But you're saying that you're supposed to dump out all liquids.
I can't impound liquids.
So the reason why you dumped out that liquor bottle is because of that.
So
Objection asked and answered.
I'm just asking for clarification.
there's a couple of reasons. So one, I can't impound liquid. Two, I'm not able to drive with alcohol in my vehicle. And at the time, I believed that I was going to impound it,
Okay.
which I said was my bad.
And when you found the bottle, you also found a cup that you believed had alcohol in the cup holder, correct?
Yes.
And you didn't dump that out?
No.
No further questions?
Just one final question. When you saw the cup in the center console that was open, was there a lot of liquid in there?
No.
Okay, so was it remnants or was there liquid?
There's a little bit of liquid.
Okay, so would it have been necessary for you to dump that out?
regarding
Given the low
everything
amount in there?
Well,
No, I could still smell it.
yeah, I was gonna say
All right.
there's only a little bit left, and you could still smell it. So now the bullshit detector's going off even more.
No further questions.
Ready to go off the record?
Look at that face. That's a woman who lied. Oh, gotta love America, chat. She's not in jail yet. Do you really make sure your body camera is off before you back up officer with your backup officers? Yeah. Yeah. So yeah, so there are some things here. So here's what's going on, guys. We got some questions here to talk about. So yes, his DUI trial went still on trial. Eric Sean says I went full BLM activist. Yeah, that's it. Allegan News says, when do you do depositions in criminal trials? There are times where you do them, typically not to this level, but guys, we've watched these trials now where these depositions do happen. It's not uncommon for like a bigger, more complex case. Or something like this where there was a suppression issue and now they want to depose her. Because the judge even said, he's like, this isn't for me to dismiss. He basically said it's up to the jury and let them do the right thing. So even the judge is like, I don't want to know what's going on. And J-Rock says she had to know she recorded herself at this point. I'm hoping she did, but it sounds like she didn't until after the suppression hearing when she got confronted with stuff. And our Tallahassee, Adam is saying, is going to have egg on their face if the trial progressed the way it did. Yeah, but we'll see. I still have somebody in the jury says, screw it. She should be not guilty. Now, Bob Masavo is saying, what about the Section 1983 issue, the deprivation of rights? Yeah, that's an issue there. But remember, it sounds like there may have been enough probable cause for him to be arrested anyway. He admits to having a couple of beers, and she says all these other things, which, yes, she is a liar. But does she have any supporting actions for it? That's yeah. And Allegan says, if you cannot impound liquids, how do you impound a car with oil, coolant, gas, brake fluid, all in it still? I mean, I think they would say, like, oh, those are in sealed systems or something, I guess. I don't know. But yeah, that would be a fair question to ask her and watch her brain melt down. Steve Trammell says prosecutorial immunity is a real problem. It is, but removing qualified immunity from police would pretty much take care of most of the issues. Because if cops knew they were going to get in trouble, like 99% of the time, it's a crooked cop. And then, yes, there's crooked prosecutors as well. But if you got rid of the crooked cops, the crooked prosecutors can't do much. And then Elegant News says, I mean, like, we like to get rid of them all, but taking rid of QI would be the best start. And then Elegant News say, did she not say he was sweating as evidence of DUI? Yes, but that's the thing. Sweating is evidence of everything. Like if she pulled him over and there was a big drug bust, she'd say, well, he was sweating and acting nervous. So in my training, that's indication that he knew something was up, and I was able to, start questioning him more. He's perspiring. His breath was rapid, or I could see his jugular was pulsating. That's one that they love to say. And I remember having an officer try to tell me that we were getting ready for suppression. I'm like, I'm not asking you that, because I think it's bullshit. Because when I think of like pulsating, it's like very visible, and it's like there's no way it was visible. And they already had enough probable cause to stop this guy, and I stopped at the point of they had the probable cause to get him because he admitted he had been, they smelled weed in the car, and they found weed in the car, like a bag of it open, and they found a bunch of coke. It's like, I'm not going to the pulsating part. I'm stopping there. Cops like, why don't you talk about it? I'm like, because I'm not asking for that.
What a dick.
Because I think you're lying. He didn't like that. But yeah, sweating is going to be evidence of everything. Everything you do to them is going to be an indicator. They've been trained on the indicators, guys. And yes, she had no clue how fast he was going. I think so. And then Atheist Ant is saying, our objection rules standards the same as they are in hearings and trials. Yes, the rules of evidence apply, and they apply the exact same way. So these are all things. Basically, courts say, you're doing a deposition because I don't want to waste my time dealing with it. It allows for testimony to be taken without having to take up court resources. So that's why they all object, and they're arguing back and forth. They would give it to the judge, and the judge would review it. And then the judge could say, okay, yep, these parts are bad. Actually, the state's objection is overruled. The state's objection sustained. And he would go back and forth through it, and then you'd be left with what's left. And then they'd have to trim it up if they were going to use it at a trial. But yes, it's the exact same rules. It's no different. You're bound by the rules of ethics. So if you act up in a deposition, you can get held in contempt. If I were to act up in a deposition, like McKinley and I were against each other in a deposition, and we started treating each other like shit, the court could sanction us. The rules all apply. You're under oath. Yeah, guys, it's no different than being in court. It's no different. That's a very good question. And Elegant News says she was fanning herself. She must be drunk. Yeah. People are drunk. They think they're warm. They feel like they're getting warm. Yeah. And then she starts sweating. She's perspiring. Hey, you know what? People who are drunk tend to think they're hot, and they get a little goofy, and they can't remember things. She said, I don't recall. I don't remember. People who are drunk don't remember. Are we sure she wasn't drunk? Yeah. Something to think about. Something to think about there. Jeez, my shirt's like all crinkly on the collar, and it makes it look like my shirt's got like these big divots in it, like a monster ate out of it.
Oh man, my screen's too small.
Yeah. Max is fastest during F1 qualifying. Well, that's not a surprise. Guys, they are doing the Japanese Grand Prix tomorrow. We're going to try to watch that live as long as I can stay up. It's at 1:00 in the morning. Do you think they only deposed her because the news got the footage of the off her camera? No. The defense already had this. They knew about it. I'm sure the defense spoke to the news, or somehow this got leaked out there. And that's that, because this, if we go to, let me see here. Where is it? Okay. Hold on. I got to bring up my history here because it'll show it. Here we go. This will be, yes. So if we switch over to this view of everything, they didn't get it that long ago. They only got it 2 days ago. So that's the thing here. So if you look down here, they posted this 2 days ago. So this was done March 7th of this year. So this was well outside. The case is already working on its own. So that's not. It's a good question, but yeah, no, fair enough. Yeah, no, there's nothing wrong with asking that question. I think it's a valid question too. The thing is, you're not going to be able to get a deposition scheduled in this much time. The day before, like if you saw it and then you're like, oh my gosh, we need to. What you would do is you continue the trial, get your deposition because of newly released evidence, but you wouldn't be able to depose somebody the next day. That's pretty much impossible.
Did you say this case happened this March?
Yeah, the guy went to trial. Yep, today.
But when was the stop?
March 7th. Oh, the stop was May 7th of last year.
Okay.
The depo was in March.
Okay.
And yeah, and I'll bring it up real quick since you guys have been asking about it. I'll pull it up so we can watch it. A second or two of it. All right, let's see here. So this is let me bring this up. So this is the state versus Calvin Riley. It's day one. It's 9.5 hours. So I mean, this goes all freaking day. And look who's on the stand now. This is about 4 hours into it, but you get to look who takes the stand. Well, oh my God, load.
Can you tell us?
Look who's on the stand now. That 1,000-yard stare. So she spent a long time up there. And if we switch over to this, the TV station out of Tallahassee covered it, and the guy live commented on it. Savannah Kelly, a report. She live, they questioned jurors. Court resumed at 10. So they start talking about what's going on there. They have opening arguments. And then they get to, they take a break after opening arguments. The jurors return at 1:15. And then from there, Officer Oliver takes a stand at 1:20. And she was on direct. And she talks about she saw him driving along, but she realized she didn't have a device to detect the car's speed. She observed it. And she says her perspective is based on the perception of speed, which is bullshit. She said his car had his headlights on, and she initiated a stop. Well, given how she lied about the bottles, I think that's probably not true. And I think that's fair enough. Although the argument then is when she pulls him over, and if that part about it being true, like, hey man, your lights are off, and she helps him dick with his car lights and they turn on. I mean, they looked like they were off in the footage in the body cam footage we have. So when they walk up to his car, the lights are off. It's like, well, maybe there was cause. I don't know yet. I haven't seen the full body cam. She confirms Riley's identity, and I'll zoom in so you guys can read this here. She's then asked to talk about her DUI training. She says he showed that his headlights were off. He asked for a driver's license, registration, proof of insurance, and she never produced the documents. But she admitted he provided the registration during the depo, so I don't understand why she's making shit up like that. But whatever. They talk about smelling the cups, and then she says it smells alcohol. So, there was a bit of an issue. Apparently, the body cam hadn't been redacted. Some of the footage is being redacted, and they're removing that. The part's talking about the field sobriety test because, yes, you are not legally obligated to take those, and you legally have the right to refuse them. So that can't be used by the jury to... And I've had that issue before, but you'd think they would have redacted this early enough to be on time, but because that was an issue, they had to stop and redact, it looks like, which, okay, it's live TV. You gotta rebound and keep moving. The judge says it's unacceptable the state waited until yesterday to redact the footage. Yes, that is true. And that is bullshit. That should have been done well in advance. So the body cam footage is played. God, they had to wait like a 2:30, an hour and a half redaction. God, this judge is going to be mad.
Yeah, I wonder why they didn't do that before.
Court's in recess ahead of the anticipated cross-examination. So, also, the police department claims it denied allegations of misconduct and will release the full footage after the trial. Oh, I'm sure there's going to be a lot of clarification there. So they talk about the judge said this motion to dismiss is ultimately a decision that should be left to the jury, meaning he doesn't want to dismiss a potential DUI because he doesn't want to look bad. This is not a situation that requires a motion to dismiss at the 11th hour. This is a behavior that was captured on video. The jury can make their decision as they believe what happened. This is a judge trying to punt and be a little bitch about it. So, 5:30, the cross-examination begins, and then there's about an hour and 45 minutes of it, guys, and it's already 2:15 in the morning. Somebody told me Sean knows how to play chess. What? I don't get it, but okay. I mean, we could see if it's. Because I'm more worried about the cross-examination at this point. Let me see if there's. Let me see. Back at 5:15. When did she? Yeah, I don't know when it's. Hold on. They're reviewing the body cam footage. Okay. Yeah, guys, I don't know what time this all starts at here, but she goes on. She's on the stand for a long frickin' time. In reality, court's back at 5:15. Okay, so going by the news stories, 5:30. Okay, so when they start back up, we should click about 15 minutes ahead. Let's see what happens. Are you willing to stick around for a minute?
Yeah, for sure.
All right, let's try this, guys. Oh, wow, they had a lot of people watching this, it looks like. They had 13,000 people watching. Good for them. Good for them. This kind of shit should be known by everyone. Let's see here. Okay.
Over for 2 reasons, correct?
Correct.
No headlights is one of them, correct?
Correct.
And you believed he was speeding?
Yes.
Okay, so let's take a look. Now we can figure out who's who real quick. Okay, so this is okay. So this is the state, this is the defense. That's Riley. Here we go. All right, here she goes. I thought I recognized the voice.
Officer Oliver, you pulled Mr. Riley over for 2 reasons, correct?
Correct.
No headlights is one of them, correct?
Correct.
And you believed he was speeding?
Yes.
Lower your voice, Jesus.
You were actually at another roadside stop when you saw him.
Correct.
You didn't use a radar gun.
I did not.
You didn't use any speed measurement device.
I did not.
You just assumed.
Based on my training, yes.
You left the other stop.
Yes, I did.
You got behind Mr. Riley within a few seconds.
Yes.
You actually follow him for a while without even activating your lights.
No, that's not correct.
That's not correct.
No.
So that's your testimony here today.
Yes.
And you had your body worn camera on during this time, correct?
Correct.
To be clear, you actually followed him for a while without even activating your police lights.
Objection asked and answered.
Sustained.
I was just clarifying, Your Honor, because previously I said lights.
Okay. Ask the question.
You actually followed him for a while without even activating your police lights, correct?
Incorrect.
That's your testimony here today.
Yes.
You were wearing a body-worn camera.
Correct.
You've received training on TPD's requirements for use of body-worn camera.
Correct.
Per policy for all traffic stops, your body-worn camera is required to be on.
Correct.
You did not activate your body-worn camera until you got
See,
in your car to pull him over.
it's actually a good question. Why isn't she uniform? Some places, cops are not allowed to wear uniforms in court when they're testifying because it gives an undue prejudice to their authority as cops. Now, when that's normally done, as we saw in like the George Kelly trial, guys, what do the officers wear? Suit and tie or something nice. She's wearing like a cardigan. Like, I can't believe that's acceptable dress conduct for her as a police officer. Unless she got fired in the meantime. I don't know. But I'm assuming that would have been like a leadoff question. Where do you know, as far as things are concerned. So I'm a little weird why she's like dressed like this, because we're not at the coffee shop.
Correct. We see you following him.
Correct.
But your body worn camera doesn't record him driving.
No, it's on my chest. You can't see it.
There is no footage of his driving pattern.
Negative.
That's incorrect?
I'm sorry. That's correct. There's no camera footage.
Your testimony is that he swerved in the road to pull over.
Correct.
But none of that is captured on your camera.
It's not.
Objection asked and answered.
Sustained.
Your testimony today is that he was swerving in and out into a right-hand lane, going in and out of lane. Correct?
Correct.
In your initial report, written the morning of his arrest, all you indicated, though, was swerving.
Is that a question?
Correct? Is that all that you put in your initial report?
I don't know. I don't have my report in front of me.
Would seeing your initial report refresh your recollection?
Yes, ma'am.
May I approach the witness with her report, Your Honor?
Yes, ma'am.
Your Honor, this
What is he doing? It looks like he's coloring.
Can you explain pretextual? Yes.
May I approach, Your Honor?
Two girls ASMRing. You guys are talking. She's on maternity leave. Jeez. Why do you guys?
Is that your police report?
You
Yes, ma'am.
And it was written the day of the incident?
Yes, ma'am.
And on that, you are sworn to tell the truth, correct?
Yes, ma'am.
And that you...
Objection, improper impeachment.
I'm refreshing her recollection, Your Honor. Looking at your police report...
Oh, there's the intern.
Now, do you still think that you put into your initial report just swerving? Is that correct?
I'm sorry, say that again.
Now you've looked at your police report. It's true that on that report you indicated just swerving, correct?
Objection, improper refreshment.
Sustained.
May I confer, Your Honor?
Yes, ma'am.
Does seeing your report refresh your recollection?
Yes, ma'am.
Did you say anything different than what you testified here today?
Objection, Your Honor, improper refreshment again.
Sustained.
Can we sidebar?
Briefly.
Can we sidebar? She's making us look real bad, Judge. This is not what we planned. She's not sticking to the script, Your Honor. Judge, help us. She's an idiot. We didn't think this perjury thing was a big deal. I'm sorry. No, it's really what happened. That's what they're doing right now. She's just staring. She's like, uh-oh, what did I do?
May I approach to receive the
Yes,
report?
ma'am.
Just read ahead so you don't get busted again. Yes. Well, if they would have been keeping track of that.
Where you pulled Mr. Riley over was in the turn lane by the median, correct?
Correct.
There was no shoulder on the right for him to pull over to.
No sidewalk.
He uses his left blinker
Yes.
to indicate that he's turning to the left.
Yes.
Once the car stops, you walk up to the car.
Correct.
Mr. Riley is cooperative.
Correct.
He is respectful.
Correct.
He follows all your commands.
Yes.
You testified that you thought his eyes were glossy.
Correct.
He's wearing glasses, correct?
Yes.
The day of, he was wearing glasses, correct?
Yes.
Yeah, that's how do you know he's glossy?
Today, you also testified that he had bloodshot eyes, correct?
Correct.
And you wrote a report on May 7th, correct?
Yes, ma'am.
And you swore to tell the truth in that report, correct?
Yes, ma'am.
And in that report, you never said anything about him having bloodshot eyes. Correct?
Yes.
Uh-oh. Uh-oh. Oh, no, chat.
You also did a deposition, is that correct?
Correct.
In which you were sworn to tell the truth?
Yes, ma'am.
And in that deposition, you also never said he had bloodshot eyes.
Okay.
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 You notice I'm surprised you didn't say you
So while
didn't
you're at
ask
the
me.
window, he begins looking for the items you requested.
Yes.
Correct? He gives you his name and date of birth.
Yes.
He tells you that he can't find his license.
Correct.
Actually, when you search the car, you don't find it.
I don't.
And at some point, you went back to your patrol vehicle
Correct.
and you ran his information.
Yes, ma'am.
And you believe that he knew that his license was suspended.
Yes, ma'am.
You believe that was the reason why he didn't have a license.
Yes, ma'am.
When Officer Moose got there, you wanted her to ask Mr. Riley whether he still lived on the Brevard address, correct?
Correct.
And you saw that notices were sent to Mr. Riley regarding the driver's license suspension.
Yes, ma'am.
But you just assumed that was 429 West Brevard Street.
I'm sorry, can you rephrase the question?
When you need to rephrase, do you understand the words coming out of our mouth?
You saw the suspensions.
Yes.
You saw that notices were sent.
Yes.
Today, you testified that they were sent to a PO box.
Correct.
But you did a deposition, correct?
Yes, ma'am.
And you swore to tell the truth.
Yes, ma'am.
And in that deposition, you repeatedly said that the notices were sent to 429 West Brevard.
Because that was my knowledge, yes.
You read the documents, you idiot.
But today, you're saying a different address.
Correct.
Because previously, you just assumed that it was 429 West Brevard.
Yes, ma'am.
What a scumbag.
Because you didn't actually see the notices themselves.
I did not.
What a scumbag.
You didn't actually see the mailing address for the notices.
No, ma'am.
You didn't see it on a physical piece of paper.
No, ma'am.
You didn't see it on a screen.
No, ma'am.
You did not see the notices at all.
No, ma'am.
When you called Officer Muth for backup, that's because you already suspected DUI, correct?
Yes, ma'am.
But you weren't 100% certain it was a DUI.
No, ma'am.
In fact, at that point, you hadn't even smelled anything, correct?
I was unsure. Yes, ma'am.
Now, when you were next to the car, you say that you smelled marijuana from the car. Is that correct?
Yes, ma'am.
Because you thought it was a DUI.
Yes, ma'am.
During the search, you found a bottle of alcohol, correct?
Yes, ma'am.
And that was found in a pouch on the front of the driver's seat.
Yes, ma'am.
And the bottle you found in that pouch was 20-gram vodka, correct?
Yes, ma'am.
And it was a smaller bottle.
Yes, ma'am.
When you found the bottle, you took it out, you put the bottle on the seat,
Yes, ma'am.
and you continue then to search the car.
Yes.
During that search, you didn't find any marijuana.
No, ma'am.
You didn't find any joints.
No, ma'am.
You didn't find any paraphernalia.
No, ma'am.
You didn't find any evidence of marijuana besides a smell.
Yes, ma'am.
Before finishing the search, you went back to that 20-gram bottle that you left on the driver's seat,
Yes, ma'am.
and you picked up that bottle.
Yes, ma'am.
You opened that bottle.
Yes, ma'am.
That bottle was sealed before you opened it.
Yes, ma'am.
And so you twisted the top of the bottle,
Yes, ma'am.
and you broke the seal.
Yes, ma'am.
And after you opened it, you dumped out the contents.
Yes, ma'am.
You dumped it onto the road.
Yes, ma'am.
Then you put the top back onto the bottle.
Yes.
And then you put the bottle back into the car.
Yes, ma'am.
You threw it on the passenger side.
I did.
And has that always been your testimony?
Everything that you just asked.
Yes,
I did not know that I opened the bottle in my original testimony.
At a pretrial hearing, you
Okay, Sean, I
swore
gotta
to
go.
tell the truth.
All right, I'll
correct?
see you.
Yes, ma'am.
See you, McKinley.
Bye.
Yep, see ya.
And you testified that you didn't unseal it.
Objection, Your Honor.
Overruled.
Yes.
So at that time, that was a lie.
Unknowingly, yes.
But now you know that you did unseal it because you had the chance to watch your body worn camera.
Yes, ma'am.
Now, Officer Muth was the other officer with you, correct?
Yes, ma'am.
She also conducted the search of the vehicle.
Yes, ma'am.
And as we keep reiterating, you've previously done a deposition, correct?
Yes, ma'am.
And during that deposition, you swore to tell the truth.
Yes, ma'am.
Has it always been your testimony that Officer Muth also searched the car?
I told you at the time I did not remember her searching the vehicle.
So Officer Muth wasn't there when you opened the bottle.
No, ma'am.
And officers rely on each other to write reports.
Yes, ma'am.
And that's because not every officer sees everything.
Correct.
And not every officer writes a report.
Correct.
Usually there's a primary officer,
Yes, ma'am.
and they're the ones who write the primary report.
Yes, ma'am.
In this case, Officer Muth was the officer who wrote the primary report.
Correct.
And you told Officer Muth about the bottle.
Yes, ma'am.
And you told her that because she was the primary officer,
Yes, ma'am.
You still lied.
because she'd be writing the report.
Yes, ma'am.
And you told her about the bottle because you were using it as evidence.
I told her that there was a bottle of vodka found in the vehicle.
Hearsay.
Overruled.
I told her that I found a bottle of vodka in the driver's seat. Now, whether she used it or not as evidence, that was up to her.
But she only knows anything about that bottle because of you.
Yes, ma'am.
Objection, speculation.
Overruled.
So her entire knowledge of that bottle is based on what you told her.
Objection, speculation.
Overruled.
Yes, ma'am.
And an open liquor bottle found inside the car within reach of the driver would be a big indicator for a DUI, correct?
Yes, ma'am.
And you told Officer Muth that bottle was open.
No.
Has that always been your testimony?
I don't remember.
You did a deposition, correct?
I did.
You swore to tell the truth?
Yes, ma'am.
In that deposition, did you say something different?
I don't remember what I said about that.
Would seeing a copy of the deposition refresh your recollection?
Yes, ma'am.
Which line and page number? 63.
For the court as well, what page and line?
Your Honor, the state's going to object to improper impeachment.
What's the page and line that you're intending to use?
Your Honor, it's page 63, lines, to include the question, 4 through 7.
You can proceed with your refreshing of a recollection.
I'm checking. May I approach, Your Honor?
Yes, ma'am.
Thank you. Lines 4 through 7.
Yeah, just
Oh,
use
sorry.
the-
Thank you. Okay.
In that, did you say that you didn't remember your exact phrasing, but you knew from seeing her
Objection,
report?
improper impeachment.
Sustained.
Amendment confirmed, Your Honor.
Yes.
Oh, so
Of your deposition.
there we go.
Seeing a copy of your deposition, did that refresh your recollection?
Yes, ma'am.
And had you previously testified saying that while you didn't remember your...
Objection, improper impeachment, and hearsay.
Overruled.
Oh, they're just losing.
Did you previously testify that you didn't remember your exact phrasing, but you knew that from seeing a report?
Objection, Your Honor, improper impeachment.
You need to ask it a little bit differently, but that's sustained.
Did you previously testify that you didn't remember your exact phrasing?
Correct.
But previously you didn't deny telling her that it was open?
No, because I couldn't remember.
But you agree that she would only know that from you?
Yes, ma'am.
I withdraw my objection.
And like you said, she put that in her report?
She put an opened bottle, correct?
And she put that in her report because it was evidence?
I can't say why she put it in her report.
I can't say why my partner put in things that would inculpate a defendant in a report. I just don't know why she would do that.
The report says that there's an open bottle, which she knows because of you. Correct?
Maybe.
Did you not testify earlier that the only way she would have known that it was open was from you?
Either what I said or what she assumed.
Looks like she's still employed, guys. They got her back, it sounds like.
So you're denying that previously you testified that she only knew about being ordered because...
Improper impeachment.
Sustained.
Yeah, it's improper, but...
A moment to confer, Your Honor.
There's a... They can do it, just they got to take their time and do it right.
Officer Oliver, you previously testified at this trial, correct?
Yes, ma'am.
You've been under oath this entire time that you've been on the stand.
Yes, ma'am.
And you previously testified that the only way that Officer Moose would know about an open bottle was because you told her it was open.
Asked and answered.
Overruled.
Yeah, that's not a... Now we're getting a
Can
contract.
you finish your question,
That was the whole question. Do I need to say it again?
please?
You previously testified under oath that the only way Officer Moose would have known that there was an open bottle is because you would have told her that it was open.
If it was said to her, then yes, it would have been me.
And you would agree that an empty bottle would be evidence of a DUI.
Yes.
And that's an open bottle that you created.
Yes.
You're the one who made it an open bottle.
Objection, asked and answered.
Overruled.
Yes.
So you're the one who created the big evidence of the DUI.
I don't know if she used it as evidence.
Officer Oliver, how many DUI arrests have you been involved in your four years as a police officer? Okay, so have you been trained on those? Yes. Is physical evidence very important? Can it be critical in a DUI case? Yes. Would an open container be something you'd collect as evidence and make note of that a person might have been intoxicated at the time they were operating a motor vehicle? If you found empty beer cans or empty liquor bottles? Notice she's not going to say no because she sounds like a fucking idiot. You know, because you've had all your experience and training, right? I think she can answer that. I mean, that's how I think about trying to put that in if I were them right now fighting with her. She wants to play games, play games. Yeah, she already asked something about be strong evidence, but you just bring it up. Would that be something you document?
In the car, you also found an insulated mug, correct?
Correct.
And that was in the cup holder?
Yes, ma'am.
And you claim that you smelled alcohol in the cup,
Yes, ma'am.
but you didn't test the contents of the cup.
No, ma'am.
And you didn't dump out the contents of the cup.
No, ma'am.
You just dumped out the contents of the sealed vodka bottle.
Yes, ma'am.
And also in that car, you found cologne, correct?
Yes, ma'am.
And you said about how you smelled it, correct?
Yes, ma'am.
That it was a strong odor.
Yes, ma'am.
It's a policy of TPD that body cameras are on during entire and criminal investigations, correct?
Yes, ma'am.
This was a criminal investigation,
Yes, ma'am.
but you didn't have it on for the entirety of the investigation.
Yes, I did.
That's your testimony here today, that you had it on for the entirety of the investigation.
For the criminal portion of the investigation, yes.
For the criminal portion, oh.
But you turned off your body-worn camera before you left the scene.
Yes.
It was off while you continued to do things on the scene.
Correct.
It was off while you continued to handle evidence. Correct?
I don't know what evidence you're talking about.
It was off while you were dealing with towing the car, correct?
Yes, ma'am.
You had it off while you were dealing with the car that you're claiming was full of evidence of a DUI.
Yes, ma'am.
And after you turned off your camera, you were still speaking with Officer Muth and Sergeant Smith about the case, correct?
If I remember correctly, yes.
But your body-worn camera was off at that point.
Yes, ma'am.
Despite discussing important things about the investigation.
I was no longer with the defendant, so the criminal investigation was over for me.
Evidence isn't part of the criminal investigation.
It is.
And handling evidence is part of a criminal investigation.
Again, yes, it is.
And today, you previously testified just moments ago that you didn't have on your body-worn camera while you were towing the car full of evidence.
I did not
Overruled.
I did not physically tow the car. I never stepped out of my vehicle. I sat in my vehicle while the car was being towed.
You didn't have your body-worn camera on while you were making sure that the evidence, the big evidence that's in everybody's report, is handled correctly.
Yes.
Correct.
And you're familiar with Apple Pay, correct?
Yes, ma'am.
So you know of ways that people can pay using
Objection,
the phone.
relevance.
Sustained.
Mr. Riley told you that he paid with his
Objection,
phone.
hearsay.
Overruled.
Can you repeat the question?
Mr. Riley told you that he paid using his phone, correct?
Yes, ma'am.
And you thought that that wasn't true, correct?
No?
Or you thought it was odd.
I did think it was odd, yes.
But you know of ways that people can pay using their phone.
Yes, ma'am.
Mr. Riley never told you his address was 429 West Brevard Street, correct?
Not to me, no, ma'am.
You just assumed that his address was 429 West Brevard Street.
Yes, ma'am.
A moment to confer, Your Honor.
Yes.
When you asked Mr. Riley his name, he freely gave it, correct?
Correct.
And earlier today, you testified that you didn't get his middle initial, correct?
Correct.
And that you would need that for David, correct?
I don't need it for David, no.
But you testified that that's what you used for David,
That's what I use for teletype, which is the dispatcher.
for teletype. And you said that you didn't even ask him for his middle initial, correct?
Correct.
Because you thought that he wouldn't give you his middle initial,
Correct.
despite him willingly giving you his name without any problems.
Yes.
And like you've repeatedly said, the car was towed, correct?
Yes, ma'am.
So it was never impounded.
Not to my knowledge.
Nothing further right now, Your Honor.
Your Honor.
Redirect.
Yes, Your Honor, before I clean the sidebar briefly.
Yes.
Look at her. She's just got like this look of like, did she realize like what I just did? Yeah. Didn't need all that evidence. Yeah. That's absolute fail. No, it's not. No, it's not. I mean, there's only so much they can do here, guys. It's up to the jury at that point. Yeah, so they can't impound liquid, then they didn't impound. Yeah. The intern's doing the trial for the prosecution, yes, like as a lead. So I think this is it for the day, guys, but we'll finish it out real quick. Let's keep chugging along here.
We were just.
Here we go.
Maybe.
Yes, ma'am.
Officer Oliver, I want to pick up right where the defense left off. We were just talking about your body-worn camera being taken or turned off after you concluded the criminal investigation. Objection.
I'll get to that, Miko.
Overruled.
Officer, what big evidence was in this car when it was being towed? Objection. Reading.
Overruled.
I'll ask the question again. What big evidence was in this car when it was being towed?
The only evidence I know of is she mentioned the bottle of alcohol and the cup that smelled like alcohol.
Okay. Officer, was that big evidence to your decision to arrest the defendant?
No.
Okay. Let's talk about looking aside from this alcohol bottle. Let's stick to the facts. What signs of impairment led you to decide to arrest the defendant for driving under the influence?
The signs of impairment that
Overruled.
the signs of impairment that I noticed myself was the glossy red shot eyes, the slurred speech, confusion when looking for documents, the way the vehicle was driving on the roadway, the swerving back and forth, the obsession speaking about the phone and other things, and then the aggression.
You mentioned something I actually want to touch basis on as well. You mentioned the glasses or the glossy eyes.
Yes, ma'am.
When you saw the defendant, did he have glasses on?
Yes, ma'am.
Were they sunglasses?
No, ma'am.
Could you see through them?
Yes.
Could you still see his eyes?
Yes.
You can't tell he's glossy if he's wearing eyeglasses. That's bull.
Now, I know you mentioned earlier that you didn't notice bloodshot eyes. Did another officer tell you about bloodshot eyes? Objection, reading.
Overruled.
Did another officer tell you about bloodshot eyes?
Yes.
So now I want to move to another point that you mentioned about fumbling documents. How long did it take the defendant to finally find some piece of paper with his name on it?
From the time the stop started, probably maybe a minute and a half.
And again, did he produce his driver's license?
No.
Now, defense counsel asked you questions about you believed he had knowledge because he didn't have a driver's license. Can you explain to the jury your rationale behind that?
Yes. So when somebody has a suspended, revoked driver's license and they still have it, we typically seize that and send it back to the DHSMB. So they typically do not have it after that point.
Now that we're talking about the seizure of the driver's license and all that, I want to move to the notices of suspension that we talked about earlier today. Officer, were you able to? Objection, Your Honor, may we approach?
Yes.
Yeah, that's the thing. Is that really too long? But if you produce them right away, they'd say that's suspicious activity too.
Now, after, oh, I'm so sorry. Yes, I'm sorry, Your Honor. That's my mistake.
All right, you may proceed.
Okay, thank you, Your Honor. Okay, I'll pick up where we left off now. Officer, after noticing that the defendant didn't have his driver's license, were you able to confirm that his license was suspended?
Yes, ma'am.
Okay. Were you able to confirm how many times he was notified of that suspension?
Yes, ma'am.
Can you tell the jury how many times he received notices?
If I remember correctly, it was 3.
Objection, Your Honor, outside scope.
Sustained.
Can you tell us what address those notices were sent to?
The
Objection,
PO.
Your Honor, scope.
Overruled.
I'll ask the question again, officer. Can you tell the jury what address the notices were sent to?
If I remember it correctly from earlier, it's the PO Box 1118. I think 5 was the last number.
Your Honor, permission to approach to retrieve the pre-marked exhibit.
Clerk is making a copy of it. We'll go sidebar as soon as she's back to look at it.
Yes, Your Honor. Okay. Defense counsel asked you about what address you had seen at the scene. Can you tell us what originally you thought the notices were sent to?
I originally believed it was sent to the residential address on David, which was the 429 West Brevard Street,
Can you tell us why you assumed that?
because that's the only address given to us on David at the time of the stop.
Now we're here today, we're talking about a different address. Is it you who's saying that it went to a different, or to the PO box, or is it somebody else, like the DMV or the DHSMV? Objection, Your Honor, call for hearsay.
Sustained.
Could I just have a moment, Your Honor?
Ma'am?
Officer Oliver, do you remember reviewing the certified driving record earlier today?
Yes, ma'am.
Where did the DHSMV say the notice was sent to?
The PO box.
Objection, Your Honor, hearsay.
That's referring to a document that's in evidence. It's overruled.
I'll ask one more time. Where does the DHSMV say that the notice was sent to?
The PO box address.
Is the PO box address the same as the one on the document the defendant gave to you?
Yes.
They're struggling a little bit to find some good questions to ask here.
Now I want to transition over back to additional signs of impairment that we noticed after you checked for the defendant's driver's license suspension. After you checked for whether or not it was suspended, were you able to interact with the defendant again?
Yes.
When you're interacting with the defendant, can you describe to us how he smelt to you at that time?
He smelled overwhelmingly of alcohol.
When you were searching his vehicle, what did the vehicle smell like?
It smelled like alcohol and marijuana.
Now, I know there were some questions about how you didn't initially smell that when you first met him.
Mm-hmm.
How far away were you from the defendant when you first approached his vehicle?
From the defendant, I would say face to face was maybe about 2 to 3 feet.
Were you able to go inside of his vehicle?
Not at the time.
Were you able to go inside his vehicle later?
Yes.
At that later point, is that when you also realized the smell of marijuana and alcohol?
Yes.
Now, officer, I know you mentioned that you have been, or how, strike that. Officer, Was this your first time smelling the odor of alcohol?
No.
Have you smelled it before?
Yes.
Does it have a specific odor?
Yes.
Is it the same smell that you smelled that night in the car?
Yes.
Is it the same smell that you smelled that night when you sniffed the cup that you found in the center console?
Yes.
Now I'm going to transition to the second substance we just talked about. Have you smelled what marijuana smells like?
Yes.
Do you know the difference between raw and burnt marijuana smells?
I do.
So are you able, or does it have a specific odor?
Yes.
Okay. Is it the same smell that you smelled in the defendant's vehicle that night?
Yes.
In your experience as an officer, is it uncommon to come across somebody or their vehicle that has an odor of marijuana and then not find marijuana inside?
Very often, yes.
Now that we've addressed your initial observations and the driving while license suspended, I want to transition to the second part of your the second part of questioning from the defense. The defense asked you about how you went about searching the car.
Yes.
Officer, was the alcohol bottle already in the vehicle when you searched it?
Yes, it was.
Now, I know we already covered this originally, but the defense brought this up, so I want to cover it again with you. When you opened the bottle of alcohol, did you have any reason to believe that it was opened or sealed?
Objection, Your Honor, asked and answered.
Overruled.
I did not know until it was opened that it was sealed.
And I know we also talked about a suppression hearing where you found out about the seal. Did you watch your body-worn camera that night after you opened this bottle or arrested the defendant?
Not to my knowledge. I don't remember if I watched it again.
Did anyone point out to you the audio and the video until the suppression hearing?
No, not until the suppression hearing.
So is it safe to say that when the defense pointed it out to you during the suppression hearing, that was the first time you realized your mistake?
Yes.
Yes, you're just now finding out her mistakes, guys. They're mistakes. Oopsie.
The defense also asked you questions about whether or not you told Officer Muth that it was open. We watched the body-worn camera footage here in court. To your recollection of it, do you recall ever hearing yourself tell Officer Muth that the bottle was open?
No.
The defense also asked you about whether or not Officer Muth searched the vehicle with you. When we watched the body-worn camera footage, could you hear her talking to you during the search of the vehicle?
Yes.
Was she also smelling the liquor in the open Tervis at the time that you were searching the vehicle?
Yes, she did.
Is it safe to say that she was helping you with the search?
Objection, leading.
Overruled.
Was she helping you with the search?
Yes, she was.
Come on, let's go. Yes, I don't recall lying. Very correct, Trish.
Could I have a moment to confirm?
All right, so does this witness need to be retained?
Yes, Your Honor.
All right, so you may step down, but please don't leave.
Yes, sir.
So ladies and gentlemen of the jury, I've been told that the state has at least 2 more witnesses. So we have options. It is currently 6:20. We can push through.
Jeez,
We
that would
can
be
break
awful.
if necessary for dinner and then reconvene and try and get this case brought to a conclusion this evening. Or we can use this as a natural breaking point and return on Monday morning to reconvene.
Spoiler alert, they came back Monday morning. So, yep, there you go. She walked off like, yeah, I don't even think she realized she messed up. So no, I don't think she felt that way. When was she terminated? She's not terminated. She is still an officer, it looks like. She still appears to be gainfully employed. Elegant News said I would have been an ass and accused her of being drunk during the depot. Her own testimony indicates that she was sweaty and hopefully she forgot her stuttering words. You know, it's you could try that, like as far as things go, but that won't get you anywhere, and the court would reprimand you for that. I think ultimately, because she's not. I mean, there's a way you could probably ask it, but not just straight up like that. You'd have to be a little finesseful. And Greg McCutcheon get to 5 memberships. Thanks, Greg. At this point, the BAC is moved. The whole thing should be dismissed. I agree. Just don't care. It's done. You need to be punished. Otherwise, you'll never learn. Court has the ability to do that, but he won't do it. Amico says, could the judge press charges for her actions? He can hold her in contempt for lying before the court, being untruthful, but that's about it. He can't order her to be arrested. He can't order her to be indicted for a crime or prosecuted for a crime. He doesn't have that authority. Remember, we have a separation of powers. That's that thing about federalism. You got like the legislative, executive, and judicial, and you got the 3. That's still the same here. So, no, she's not going to be held accountable. Nothing's going to happen to her, sadly. She'll just be a cop down in Tallahassee who does planting evidence, yeah. Yes, I was stumbling across words. You can't hold it against me. Yes, that should be, what she did should be considered evidence tampering, but yeah. It's a very least an ethics violation when they don't have ethics codes to run by. Their law enforcement certification isn't conditioned on that. So, yeah. Once this trial's over, they'll release their investigation and declare that there was no wrongdoing. She just needs retraining. What happened to the papers falling from his visor is probably a bunch of garbage. Well, Rocky's saying, why do judges and prosecutors have immunity, but the president don't? That's an issue of the designing of the Constitution, how things were set up. I think they also didn't anticipate power and things going this way. So, I mean, you could consider it like a loophole, but they didn't think that was going to be this bad. Except he was driving impaired. Well, it's not clear that he was. There's a lot of evidence that leans towards that, but it's muddled down with all this bullshit that's there. And yeah, I think it's only, getting rid of this. Oh, it's only fair. Because if you get rid of this from now on, they're going to realize, oh my God, if we screwed up, remember the last time we wasted all that time and money. Well, people tend to remember that. We all remember things that way. Taking away costing time and money. That's how we learn. Eventually we keep making mistakes. So if I fall asleep, super I can throw on my face. But yeah, we are all we don't know that he's speeding since it wasn't measured. Yeah, but they could say I saw a car going by at a high rate of speed. Now she says it was like around 10 over, but there's going to be enough cause for them to make a stop on the car. If he's swerving and whirving and bobbing and weaving, that's going to be enough. And to go from there. So, there's going to be, the police often exaggerate their reports. Oh, yeah, they are. And yes, we have to be realistic. Yes. Are we streaming tomorrow? Yes. We're going to catch up Nikolai Mew as far as we can get, and then tomorrow on Sunday we are going to do George Kelly. So we are going to start Nikolai Mew probably in the afternoon at least, and then go from there. So headlights off was a problem. Supposedly it was off, but I don't know. Did I say an F1 stream or C1? Yeah, we'll probably do the Japanese Grand Prix tomorrow night because that's at 1 a.m. So we'll probably take a look at that, guys. So that is it for tonight. Thank you for everybody being here. Make sure to watch the top of this brazen of a liar. So, good night, guys. Take care, everybody. Tips on hunting and even talking the law. Whatever you do, just don't talk to cops. Even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty. But please talk to a local attorney. Was that the fat guy Rick hated yelled at?